Our conclusions are no provision under notification number 5465 dated 11/3/2020 and the office memorandum dated 5538 dated 11/3/2020 has been demonstrated to be violative of any provision under Article 21A of the Constitution or any provision under the RTE Act or ORTE rules. Clause 24 of the office memorandum containing implementation guidelines is not hit by the maxim nemo judex in res sua. The rationalization policy cannot be held to be illegal merely on the ground that there is no such prescription under the RTE Act or ORTE rules. The validity of such policy could be successfully challenged only when they were shown to be defeating the provisions of RTE Act or ORTE rules, and thereby Article 21A of the Constitution. With reference to question number 4, we are of the view that opinion recorded by the learned single judge is not in consonance with Rule 6(2) of the ORTE rules. For the reasons noted above, the impugned judgment dated 4/5/2021 passed by the learned single judge deserves interference. The judgment is accordingly set aside. Appeal is allowed.
I agree.
Matters for to be mentioned. Item number 1, WF 440 of 2024.
In this case, my lord, I am appealing for the opposite. Yes, I am appealing opposite part number 1. 42 cases were tagged to the common judgment passed. Only one writ appeal filed by that time. In the meantime, many writ appeal filed by other advocates there. So I pray all
See, this matter was heard and this matter will be decided. All right. Only
So,
judgment
this
is
is
to be judgment is to be
Only that is
delivered.
my
So
submission.
it has come only for certain clarification. Clarification for the reason that while going through the impugned judgment, we found certain provisions which we could not notice in the book. Therefore, like 10A, 10B, where is that? 1972 rules. Do you have?
I'll provide that 72 rules in course of the day, my lord, because
72 rules are there.
yes,
In the book there is there.
in 72 rules, if this book is with my lords, that
Please, in fact, make that clear.
yes, ma'am. That is rule 14 is there.
Rule,
14 of the 72
Just-
rules.
problem is different.
That has been
The problem is different, Mr. Just a minute.
Dear lords, is looking at 10A.
Come to 2.1 of the judgment.
Well,
Where is that? This refers to Rule
the rule
10B,
15 read with rule 10B and 11A of the rules.
10AB. Just see, it is contended that provision to 10AB and then 11A. Where are these rules?
Well, may I Yeah, I have given that 72 rules.
72,
Yes.
we had 72, but all right. Please read 2.1.
Well.
Please read. It is contended that as provided under 10AB,
Well, yes,
could you see that?
yes, I am reading it.
Where is that?
Well, that's on the rule. Lordship has seen that rule 10. 10 is 10A is the eligibility criteria and 15 is the constitution of the selection committee.
Therefore, when this judgment refers to 10 so and so are eligible for promotion, so where is the eligibility for promotion under 10AB? We just want to be clear.
Yes, Malad.
That may not be provision, that might have been wrongly noticed,
Yes,
but we just wanted to be clear. Can you clear this aspect, Mr. Counsel?
May I please taken up tomorrow, my lord? I'll
We will take up.
Tomorrow.
All right. Monday.
I'll try to.
Just examine.
I'll try to. I'll try to.
Because despite my best of efforts,
Yes, ma'am.
I could not find out
yes,
this 10AB and any provision under section under 1972 rules,
Right.
which provides that on completion of 3 years, one becomes entitled for promotion.
My lord. Tomorrow I'll try.
So this I could not find out.
I'll try.
And in the there we don't know, there might have been some amendments also.
no, my
In the meanwhile.
Amendment 93.
93 amendment
No, no.
repeals 72.
Under 72, no amendment.
Under 72, no amendment, and your claim is under 72.
Yes, under 7, no amendment.
Therefore, Mr. Under 70, your claim is based on 72.
My lord.
So you will have to demonstrate that under 72, you were entitled to promotion from a retrospective date. That is the only question. So very simple.
yes,
And the provisions which have been referred to, we could not
That
locate. Section Rule 15 is there under the new rules.
new rule.
Please.
Do you have copies of that rule?
No. I have not brought the proof.
All right.
That's why I brought
The present matter has been listed for certain clarification from current counsel for the parties.
your lordship has seen that 10A.
10 capital A, it's not some 10
Yes, Malad.
small
Where
a.
the 10A, that is the eligibility criteria
For recruitment.
for, yes, Malad. For recruitment by selection of a candidate must satisfy the following conditions. He must have served in the lower subordinate education service for at least continuous period of 3 years. And then he must have passed a bachelor degree on an equivalent examination of a recognized and must have successfully undergone
So that is not promotion.
a selection, by that promotion by way of selection.
It is not 10A, 10 capital A.
10 capital A, sir.
Later.
Then originally in 72 rules.
That one, not-
No, it was not there.
yes, it was not there. Subsequently,
So somewhere
it was subsequently in
After
1977.
after 72, it must have been inserted
Yes, yes.
somewhere.
It is in old book.
All right, Monday.
Well,
Okay. Counsel for the parties on the counsel for the party in on the point as to whether any rule in the name of Rule 10 bracketed A bracketed B of the rule of 19 of Odisha Subordinate Education Service bracketed General Branch Rule 1972 exists or not. Rule 9 is there, was there or not in the statute book. Full stop. For the said clarification, let the matter be listed under the same heading on Monday. Well,
Monday, matter, only Tuesday, Monday I have problem, Tuesday.
Tuesday. Rules. Rules.
Item 2,
Gender affidavit to objection filed.
File.
Man.
Counsel appearing on behalf of the petitioner seeks adjournment to file a rejoinder to the counter affidavit filed on behalf of the respondent, opposite party, to stop this case on Tuesday.
2 weeks.
Tuesday.
Much of it.
item number 3. CMFL 68.
Kindly see order to 39/2024. Para 5, your lordship, by mistake it has been mentioned that my WA number 131.
Just a minute. Order dated? Order dated.
391. 392. Para 5.
Para 5.
My. The WA has been mentioned at 1310/24.
1.
Your lordship mentioned that WA writ appeal number WA number is 110/2024.
It should be 23.
23.
There is apparent typographical error in the order dated 3/9/2000 in paragraph 5 of the order dated 3/9/2024, wherein WA number 1310 of 2024 has been typed in place of WA number 1310 of 2020.
23.
Stop. Said orders shall be read accordingly. Stop. Accordingly, it is directed that let WA number 1310 of 2024 be restored to its original file. Just a minute. Yes,
23 my lord.
23.
23 may be restored.
All right. 23.
Apply.
Item 4.
May I please notes?
Better.
Notes with my lords, kind for this and I'm through VC my lords. I'm for the petitioner.
This is that matter also.
My lord, in order to justify the grounds taken in this writ application in the form of public interest litigation, I humbly beg to invite my lord's kind attention to section 3.
You are the only person who has right to speak.
No, my lord.
I think my lord friend was not there in the last occasion. That is why I'm not.
He's not aware about the last
Not
occasion
aware.
proceedings in the.
My lord,
Last
I was
occasion, we not-
hospitalized last occasion.
Addressing your lordships about that public interest litigation, that appointment of managing director. So
Lordship said directed all of us to formulate the points so that it can be easier for Lordship to take up the matter, dispose of minutes. I think Lord Arbitration generally is not.
All right, it will come on Wednesday. On Wednesday, but with a different bench.
different.
Maybe with a different bench.
Can I place a request, Lord? In those PIL, in that PIL matter, I am a party and I have just recently entered appearance last occasion. I am also supposed to file a counter there.
File it.
That's why, Lord, I am just speaking about 7 days or 8 days.
Week after, lordship. Week after.
Therefore, it will come on Wednesday,
That will do.
next Wednesday.
That will do.
Can your lordship direct the
These are all pre-Diwali discussions which happen this side.
The other connected matters are also directed to be heard by a special bench, but other connected matters, they have not served copies. I request my lord friends to give me copies at least in the other cases. Because lordship will hear this matter.
We will all serve copies.
Yes.
We will definitely serve.
There are single judge, single bench matters which are pending, some matters are there pending before the single judge. So those also will be, those have been tagged
Those have come for reference. These matters
They will be
pertain to a
argued
particular bank. So keeping in view to the PIA, the lordship have been pleased to tag these matters which are connected and concerned to the bank only. So I don't think any other matter concerning this bank is pending.
Well, let us decide. It's a question of-
One item matters,
WPC 20/2024. I pray, my lords, let there be direction to the petitioner. He should not preside over the board meeting.
How can?
Nay, my lords, because he has been disqualified from the post of directorship. So if he will, by virtue of a stay order, he will preside over the meeting and pass policy decision. It will be difficult.
Maybe we will decide.
Lordship, I pray that
Address us on
decided.
Wednesday.
direction, he should not preside. over the-
Address us on Wednesday.
Man,
Wednesday, that will. So great.
Maybe pardon to make a mention, my lords.
Let
This very-
let the matters be listed on, just a minute, madam, listed on Wednesday. I'll stop. The parties in the meanwhile shall be at liberty to exchange their pleadings. Yes, yes, madam,
My lords, I want pardon to make a mention with regard to a lease matter, my lord,
not in
which
this
has been
case.
previously disposed of by a member.
All right,
of
we are
benches of
coming back.
this time.
We are
Beg
coming.
to make a mention, please wait for the regular bench.
All right.
Only benches here.
Disposed of previously.
So what she's saying is, this matter has been disposed of by lordships and my lord Justice Raman.
Yes.
All right.
Previously by 2 written petitions have already been disposed of with the same cause of action in which Mr. Honorable Justice Raman was a member. So I place the matter may be listed before this bench.
Same
my
bench, right?
Yes, sir. But
Any other
he's
bench
already a
can-
member, my lords there.
Give your slip.
Yes, they do.
Mention my lord, the matter relates to admission into ITI courses. In similar, it
Give your slips.
similar, homework.
My lordship, pardon.
Yes,
Similar.
my lord.
Yes, yes, ma'am.
Public interest and.
Give your slips.
I may pardon to make a mention, my lord. During my lord's absence of your lordship's interim order,
During subsistence of your lordship's interim order, my lord, the opposite party number 2, my lord, created a third party interest and directed me to hand out the charges. So, my lord, I have filed a IA, lordship may take up tomorrow.
My lord, I beg your lordship's pardon, my lord.
Lordship, begging pardon to mention, lordship, I have filed one IA. My appeal was disposed of only due to the non-appearance. It was the COVID pandemic time, lordship. The appellant died during the hearing of appeal, and her daughter was willing to join the.
Your criminal appeal was dismissed.
Yes, lordship, only due to the non-appearance, and it was dismissed by the Honorable Justice Rato bench.
All right, we will see.
Lordship, may it be listed for tomorrow, lordship?
Give your-
Give
My lord, I beg your lordship's pardon, my lord. My lord, one bail matter, tied up bail matter, which was which has to be listed before Justice M.S. Sahu, my lord. But his lordship is sitting in division. So I therefore request your lordship.
Give your
I have given a memo, my lord.
All right.
My lord, a lady in custody, my lord, since 2024 June, my lord.
All right. All right.
Fresh matter.
Lords, your lordship's list today, item 44, 46, 48, and 49. These are all these nursing college and all those matters which may be covered by your lordship's order yesterday, except the last item, item 49. So your lordships can simply say that all matters, the similar orders what your lordships have passed yesterday.
Yesterday?
Yes.
I have given the list also, my lord. Describing everything there.
Nursing and physiotherapy colleges, but the same issues and everything. My
Physiotherapy, then which are physiotherapy? There has to be slightly different.
48 sub item 1 only.
Only that is physiotherapy.
And 49, there are two items. 17905 and 19237, which is the last one.
Item?
49, the last item.
Two items.
Yes, ma'am.
And what is 56?
56? No, 56, my senior. My
56 is,
that is different.
It is 56 is regarding flight certificate of the.
So physiotherapy is two.
Yes.
Which you pointed out.
Yes, ma'am.
Matarani.
So just be here.
No,
when the-
Matarani is nursing. Physiotherapy is only one, that 49 last item. Last sub item.
No, you said 49 is 48, physiotherapy is 48.1.
No, no, my lord. My friend had clarified. No, it's under the nursing. 49, the last item, sub item. That is physiotherapy.
Same college, that is where the confusion is.
Yes.
Okay.
49 last item.
Last item. That can be taken up some other day. Your lordships, I think, will fix those matters.
49 last item is what?
Is physiotherapy.
19413.
19237.
No.
19495.
No.
Lord, that is
19413.
19237, my lord. Item 49, the last sub item.
49, the last one.
19413. The last but one, my lord. The last two, I'm extremely sorry, my lord.
We have to check, cross check, and then
No,
come and check.
no, my lord. I'm extremely sorry, my lord. Because the last was two lines, so I couldn't mark it. Last but one.
Get a larger screen for the mobile.
Lord, your lordships have helped with this, but we are yet to got acquainted with
All right.
this one.
Be here when the matters are called.
Yes.
So that all the parties
Yes,
are here.
they'll be there and can be.
I may pardon to make a mention, Lordship, item 25 is Madam Senior Advocate Madam Pamirath is not is in some personal difficulty.
All right, let the matter be called. Please be here.
Grateful.
Pardon to mention, my lord. Item 42 kindly be taken up today, my lord. Otherwise, it will infringe us.
42. Let us see.
Yes.
Let us try.
Item 43 may kindly be taken up today. Admission cancellation. Item 43 may be taken up today.
Let me see.
Pardon, your lordship,
Let-
item 52, your lordship, I had mentioned yesterday.
So when you say that your matter should be taken up today, Mr. Counsel, when you say that your matter should be taken up today, you can also say that which are the matters which should not be taken up today. So you may have to furnish the list of the cases which are less important. All right, we will try.
For orders, item number 27.
This is regarding that rehabilitation method, my learned friend has asked you. If he agrees with this order, your lordship can dispose of the requisition. Your lordship.
Is agreeable.
Yes. That your lordship has disposed of matters.
Dispose, you not remove the defect. What is the defect?
In first case, madam.
Yes, first case.
What is the delay?
I for condemnation of delay. This is a delay of same order, that was 222, this is 112 days. Mr. Arjun Chandra Behera. Delay is condoned and the writ appeal is disposed of in terms of Bindu Sagar Samatara.
Item 28 also same. My learned friend is also appealed. 28 is also same.
Here, Mr. Misra. Let us see what is the delay. Mr. Kuntia, why you not removing the defects?
I have instructed.
You have not. This is 86 days delay. Same order.
29.
Wait, please, Lordship. The last order, if Lordship looks at, Lordship directed me to take steps.
So we have to wait for another date because
Only one opposite part number 6
yes.
notice had not been made.
We have instruction to appear for all the application of respondents. Today we are filing.
All means
All the respondents. We have options.
including 6?
Including 6 men.
Already. Please, you are, I think you had appeared for the others.
Others men.
Mr. Kanungo,
Mine.
have you filed wakalatnama or you?
Today we file for other respondents. We have.
Acha. Mr. Kanungo, Mr. Lalatendu Kanungo, learned counsel submits that he has instructions to appear on behalf of all the opposite parties, including opposite party number 6.
So also the substituted LS men. They have filed another petition to substitute some of the LS men.
Okay, just let us see.
200.
200. Oh,
Serial to 200. 200. I had 200 of 224 men. Flag B men.
200 of 2024.
that has been filed
Flag
by
B,
each
madam.
of them. Acha. He also submits that IA number
200.
200 of 2024 has been filed by the legal heirs of
The appellant has filed to substitute the legal heirs. He is appearing for the legal heirs also.
sorry, The
appellants.
Filed to allow the same application and grant leave to the present petitioners who are the legal representatives of the original applicants to file and contest the actions here.
Who died?
Well,
Who died?
but if your lordship looks at paragraph 1, it's mentioned.
What is mentioned? Paragraph 1, it is not
So
mentioned.
1 to 3 have died.
1 to 3 appellant.
Look at paragraph 2.
This is substitution in place of whom?
On behalf of the appellants 1 to 3.
So unless the CMPL is allowed, how can we allow the substitution in the?
Unless the
No,
limitation is not-
sorry, you have filed it in the CMPL.
here filed this.
I have filed.
IA 200 of 2024.
Appellant.
You have filed.
Right.
So I
Unless
have
the
filed.
limitation petition
See,
has
you
not
have
been granted,
filed
they should
substitution.
consider later on.
because some of the petitioners have died. Petitioners have died.
So appellants, that's petitioners. Lordship, right.
Appellants are petitioners. Petitioners have died.
Right.
And then where is the question of him appearing for the persons?
No, so you please confine your prayer to respondents.
Respondents.
Opposite parties.
Opposite party respondents.
Appellants, he has appeared, he will press that application. So you are confusing us by saying that you will appear for
No,
legal heirs.
You cannot appear for the legal heirs.
Respondents.
Yes, respondents, that is all right.
Respondents.
This application is filed by the legal heirs of the appellant
Yes,
who
yes.
died.
Yes.
So therefore, he cannot
No,
appear
no.
on their behalf.
No.
He is appearing for the respondents.
We have instruction to appear for other respondents. We'll file after, no? Okay.
Allow the substitution. What is the delay in filing substitution application?
5 years. ma'am.
Delay actually what
5 years.
happened?
ma'am.
Delay actually is not account of the fault of the client, the party. Actually, the lawyer who appeared, his name did not appear in the list. So as a result of which the appeal was dismissed for default. The appeal relates to properties of the family.
Yes, I remember. Then you said the advocate had expired, but
Sir, actually,
much before that it had been
no,
dismissed.
it has been dismissed due to non-appearance of the counsel. Name didn't appear. Clients were under the impression that it is the safe hands of the lawyers. But when the other side wanted to come into over the land and try to make construction, then he wanted to inquire. He came and found that the lawyer has expired. It has been dismissed for default. During COVID, actually, he could not take any steps. After COVID, when he actually made the counsel, at the time counsel was not there. So he contacted the office. In the office, they say, you come, all the files are there, but you come later. He actually
No,
suffered from.
that is not very relevant.
That is not.
The relevant is, when did you file your CMAPL?
Right.
When did you file your CMAPL? When did you file your CMAPL?
Sir, after COVID,
Just give us date.
When did you file your
That is
CMPL?
for a different reason, because
And were the appellants alive then?
so it has been filed in December 2023.
December 2023 you filed. And when did these petitioners die?
19/8.
1, 2, and 3.
So 19/7/2018.
18. Then how could you file this application on behalf of dead persons?
No, we filed by
Okay.
substituting with the legal.
Appellant 2 and 3? When
Yes.
did they die?
Right.
When did they die? Give us the date.
Date of filing.
Date of death of appellant
Date-
2 and 3.
Oh, lawyers.
Appellants have died.
Appellant, I have mentioned, my lord.
Mention, we want the date. Without looking at the file, we want you to assist us.
21/5/2011.
Appellant two.
Mishra,
Yes.
just
Number
we are,
two.
we are on a different point altogether. Who is petitioner number one in CMA PL 1865 of 2023?
He died on 10/8/2000.
Then he died on 10/8/2000. Then how could you file this restoration application on his behalf?
No, well, we have filed with the leave, the substitution application also filed.
That is different.
Right. We also filed the substituted application and the
Substitution application we have filed in 2024. The CMPL has been filed in 2023 by the dead persons.
But there are other
And
appellants are
in
there also there.
That is what
CMAPL,
I'm asking about
Mr.
the
Mishra, you could have stated in the CMAPL that these persons who were parties have not been
Number 4, 5, 6, 7, all are alive. Man.
Okay, so
They're alive.
that you've stated in your CMPL that they have died.
1 and 2 died.
So who's
1, 2
one,
and
who's
3.
two?
Ghasi they also died.
just see your prayer in paragraph 1.
Para 2, it is mentioned during pendency of the said age of the ordinary appellant 1 to 3 have
You are describing them as the petitioners, as if they are alive.
No, they were not alive.
They were not alive.
They died prior to that.
All right, you file your affidavits. Let them file.
Have you served copy?
No, they have not served.
Please serve copy of the IA for condonation of delay and the
I'll give a
substitution.
complete date chart to explain.
No, first serve him a
I'll
copy.
serve a copy.
Thereafter, date chat. That will remain. Mr. SP Mishra, Learned Senior Counsel, undertakes to serve a copy.
Oh,
Learned Counsel for the petitioner undertakes to serve copy of the IA.
Moderate.
Copy of the IA number 429 of 2023 for condonation of delay and IA number 200 of 2024 filed for substitution of appellants number 1, 2,
1, 2
and 3 on the Learned Counsel appearing on behalf of the respondents in order to enable him to obtain instructions and file objection if so advised. List the case on 12/11/2024.
So for the CMAPL application, madam, regarding the restoration.
All right. Also, as well as the CMAPL
I'll
application.
also serve a copy of the same.
Yes. All right.
Item number 30.
Where is Mr. Mahanti? Is there?
There is a delay of 443 days. 554 days. 554.
What?
500.
How much?
550.
As per the stamp reporter, 555.
Sorry, 550.
The issue?
The issue is regarding that rehabilitation assistance scheme. Lordship can get the order at Annexure 3, page 52, my lords.
So, unmarried daughter?
Yes, madam. What has happened in this case, there are 6 legal heirs are there.
Yes.
At the time of death, this respondent was 15 years. As she has not attended, even if other legal heirs are there,
Legal heirs means her brothers.
no, sisters.
It's other sisters.
Other sisters that are there, they did not apply. After 3 years, she had applied.
Okay.
So limitation.
I may be wrong, but other sisters, were they married sisters?
No,
Because as per your rule,
unmarried sisters.
they were also unmarried.
Yes, ma'am.
All right.
For a moment, let's see page 22
Page 22.
Ma'am.
What is that?
of my pre-appeal.
Page 22. Oh, is the application?
My lord, that is the legal heir certificate I am showing, my lords.
Yes.
Lordships. Got it?
Yes.
Your lordship may see serial number 4, 5.
Okay, 2 are married, 4 are
2 and 3 are married daughter.
already.
4 and 5. And also 7 is
There is direction to you to consider only.
in taking into account the risk. That what is the problem? My lord, that your lordship has seen that judgment. Direction has been given, my lord, to consider his case in accordance with the ratio decided in that Molananda City case. Your lordship may see, it is all may read my lord, para 7. It is also submitted the grounds on which the claim of the prisoner was rejected and no more rescinded in view of the decision of this court in reported in the case of Ajit Kumar Barik versus State of Odisha and others. Last paragraph, in view of such steps taken, the claim of the petitioner should not have been rejected. In any view of the matter, this court finds the petitioner's claim has been illegally rejected and accordingly this court is pleased to quash the said rejection available at Annexure 7 so far as it relates to the petitioner and consequential order at Annexure 6. While quashing the same, this court directs operator to take appropriate step in the matter and take in accordance with the rule at the time of death of decision in view of the decision of the Honorable Apex Court in the case of Malayananda Sethi versus State of Odisha. Absolutely.
So what is wrong?
So if that Malayananda Sethi, what has happened, my lord, you know that so far as Malayananda Sethi is concerned, that it was held that the old rule will govern the field at the time of consideration. Enter dispute centers around whether at the time of consideration whether the old rule or the new rule will govern the field. So now all these matters, even if Malayananda Sethi was passed by the Honorable Apex Court, subsequent judgments that and in that Malayananda Sethi case, that Honorable Apex Court said, keeping in view the peculiar facts and circumstances of the case, that Malayananda Sethi case was decided by the Honorable Apex Court. Where this Honorable Court in Malayananda Sethi case has held that on the date of consideration, the rule governing the field will regulate the mode of selection. That was passed because taking into peculiar facts and circumstances of the case.
You can say this is not peculiar.
Yes, ma'am. But in that Malayananda Sethi case, that in peculiar facts and circumstances, that Honorable Apex Court has allowed that. That my lord's order was, judgment was set aside. There, your lordship has decided.
This is not peculiar. So therefore they can take it. No. Yes.
Yes, may I please, your lordship.
Let us see Malayalam Sethi.
I am not come because it's the
Tomorrow?
orders by tomorrow.
Yeah, what do you want?
I filed my objection in so far as the delay.
You have filed.
I have filed the objection so far the delay with the condemnation petition they have filed.
How much money will you take?
No, this is not a case that
All right.
the issue.
You will not take all right.
No,
Then we'll decide.
You will decide.
I may permitted, my lord, so far the submission made by my learned friend that the issue that is involved in this writ appeal, my lords, it has already been settled, my lords. In the case of Ajit Kumar Barik, that has been referred in paragraph 7 of the judgment. So when the other legal heirs are available and subsequently another person having no objection from other members of the family applied and she will get the appointment, that has already been settled.
I don't think that he's seriously objecting to. He is objecting whether your case will be decided as per the decision of Malayananda Sethi regarding the rule which was prevalent at that time or at the time of decision. He is objecting. Am I right?
Yes, ma'am. So far as Ajit Bari case is concerned, that is not applicable to him.
Oh,
Because
that also is
that
disputed.
is
We'll
not
just-
applicable. I am explaining in one line, my lord. In Ajit Bari case, that 2B was defined, that the order of preference. Here, if the order of preference is be taken into account, at the time of his consideration, he was 15 years. So he applied after 3 years. So on the ground of limitation, his application is to be rejected. That is not covered under Ajit Bari case. If he would have been eligible at the time of consideration of 2011, then his case is covered under Ajit Bari case.
May I submit, my lord? That is not the fact, my lord. The Honorable Court, the issue has already.
Yes.
Honorable Court has already
consent
settled
of
the
the
issue
parties
to the extent that when other legal.
So you have, do you have the original copy of the writ appeal?
No.
No?
But only
And
delay
sir,
on
notice has been issued. He has appeared and has filed his objection on my limitation.
All right.
I'll serve the copy of the writ.
Copy. Writ appeal. 1 week.
Mr. M.K. Kuntia, learned additional government advocate, undertakes to serve the copy of the appeal memo
By tomorrow, ma'am.
on Mr. Ranjit Mahanti, learned counsel, appearing on behalf of the respondent by tomorrow. List the case on 5/11/2024.
But since you are opposing his prayer on technical grounds, if the daughter is otherwise eligible for appointment, you can appoint. We shall keep the question of law open to be decided in appropriate case.
Then you'll also say consider, you not, because we have to verify many things.
All right, after.
Well,
They have already considered my case and rejected on the ground of 2.
again, reconsideration, my lord says, we can reconsider your case. But
Without interfering with the judgment on the, we can dismiss the appeal on the ground of delay, making it clear that the question of law shall remain open to be decided in appropriate case. Yes.
Item 31.
Jointly requested.
31.
What the respondent,
Yes.
they have paid some money, but I have to take the instruction and file affidavit. Let it come next week.
On appeal.
Mr. Das, where is he? Last occasion I was saying that we have to pay the amount. Have you received the gratuity amount?
I have to take instruction and.
Hey, you have to take instructions. 20 days have elapsed, you have not received instructions because last date we had directed.
My lord.
He doesn't have a phone number.
My lord. But I am in hospital work, as my father-in-law is in hospital. I'm busy there also.
None appears for the petitioner when the matter is called.
Appellant.
Sorry, none appears for the appellant when the matter is called. Ms. Archana Mahanti, learned counsel for the respondent, prays for a short adjournment in order to obtain instructions whether order dated 7/10/2024 has been passed by this court has been complied with. This is the case on 5/11/2024.
Item 32.
32. Here the order of the Honorable Sunita is under challenge.
No, why this matter has been listed for orders?
My lord, dispensing of certified filing.
Why?
I have applied certified copy of the order that is not.
When?
My lord,
When did you apply?
on the date of filing of the
When?
filing of the 23rd of October.
And you have not received?
No, not received. By
23rd of-
tomorrow or by next week I'll file.
This, you can get a certified copy within a day. What are you saying?
You must not have inquired whether it is available or not.
Today itself inquired and I'll file. I want to
Necessarily these applications are coming dispensing with filing of a copy.
I want to.
To file an application online, you will get it today or tomorrow.
I have already filed a place for dispensing.
IA 7207 of 2024. Mr. Moon, learned counsel, undertakes to file the certified copy of the impugned order by Friday. Friday is a holiday. By 4/11/2024, List the case on 12/11/2024.
Take up this matter.
There's some
Urgency there. They are going to evict. Yesterday they were trying to evict, and I undertake to.
But what is this? Is it maintainable?
Yes.
Against the order passed by the
Yes, you come to page 15, impugn order.
27 order or what is it? Yes.
Let's come to page. No notice was issued to me.
No, wait. Which is the impugn order?
Page 15.
1/5.
Yes. Here I am the opposite party number 2 in the writ petition. Earlier application filed by the petitioner was rejected. Again, he filed a second writ petition without making any prayer against me. But the order was passed against me without issuing notice to me.
DRT.
Surface case is pending for the DRT.
No. We are saying whether the writ appeal is maintainable.
Yes, final. Page 15 of the appeal. First of all, my lord, the writ was.
You challenging the order for challenging the order, refusing to recall order dated 6/9/2024.
Both order. Original order and recalling order.
Where is the original application?
Page 15. You see page 15.
Page 19.
15. The order passed in the original writ petition.
Item 32.
Yes.
You are the borrower.
Yes.
But they are the auction purchaser.
And here auction purchaser filed, and here she come to another thing, how he has suppressed. Page 22.
This has come for orders, it will come for admission.
Tomorrow,
Will you file it in course of the day?
yes, tomorrow you call this.
Mr. Moon, learned counsel for the appellant undertakes to file the certified copy of the order. Please, this is an IS 7207. Certified copy order in course of the day. List the case day after tomorrow. List the case tomorrow.
Yes.
For fresh admission.
Item 33.
Yes. Disposal.
33, lordship, in fact, this matter for us ready for hearing, lordship, this matter. Last occasion, it was taken up on the lordship petition filed by the opposite party for vacation of interim order. And your lordships clarified that order on 1/10/24. But it ought to come for final disposal because pleadings say. Because
Lordship may kindly see the 1/10/2024 order, your lordship. That lordship did clarify. But you see, my interim application for vacation of stay is pending, my lord. And last question, my lord, paragraph 7 of the order. The considering the joint request made by the learned counsel for the parties, let the matter be listed on it.
that is for
The
final
both-
hearing.
both the- yes, my lord.
That is for final hearing. I am ready to argue.
Because-
In order thoughts, I am ready to argue.
Because, my lord, the interim order is the my annexure A/5, page 42, the authority has direct me to not to execute any work, my lord, even though the agreement has been executed and work order has been issued in my favor, my lord.
You'll hear it on priority basis. We will hear the matter on priority basis whenever you want.
As your lordship says, my lord.
Whenever, just give a date.
Lordship, any day, your lordship.
Any date, give
Yes,
both
sir.
of you
Yes, lordship. Tomorrow, your lordship.
tomorrow.
Let it next week, lordship, it will better next week, lordship, because
We'll discuss matter on Tuesday. We taken up at 2 p.m. Say at 2 p.m. But
Batch matter?
Hmm?
End of batch.
Good. 12 p.m.
12th.
lordship, great.
12 only, yes.
Yes. Interim order there, lordship.
Interim order is not, my lord.
That-
Last
that-
occasion.
Interim order has not been extended.
Yes,
That is not,
because my last
Because
occasion
it was
has been
clarified.
clarified, but
That
it
is
was
the-
not been extended.
it cannot be understood like this. Once.
Grateful, my lord.
Orders back over.
Specially urgent matter, item number 1.
My lords, may kindly see the last previous order dated 2010
May I
to
please,
2020.
I had undertaken to submit a note and submit it.
Petition. Appellant, sorry.
And cases had not been mentioned in certificate, so I was required to submit a note.
Yes.
My lords, has directed to address this court by my learned senior on the fact of suppression of facts matter regarding non-disclosure of the previous writ petitions. My lord, therefore, I have cited 2 judgments and last occasion, my lords has
Yes.
I have submitted a note, madam. I had undertaken to submit a note as to what had happened.
Why did you suppress?
And some of the decisions, the cases are filed before the honorable learned tribunal. Tribunal became non-functional on 5/8/2018, 19. And thereafter till
Why did you not mention all those facts in your writ petition?
para 15 of the writ petition.
Why costs should not be imposed on you?
So those cases were, my lord, not a single case was disposed of. In all those cases, representations were directed to be disposed of. And the
So why
pair
did
was
you not tell the court that these were cases filed which were disposed of with this order? How much cost?
You not say, my lord, some of the cases filed before the tribunal, they were hanging because they are the.
You could have disclosed everything. Tell us how much cost.
And
You abuse the process of the court.
because
You
the-
file writ petition with false averments.
Your lordship, I kindly turn to page 15, para 15 of my writ petition.
Para 15 or what?
Writ petition, which is challenged here. 14 and 15.
So we should.
7 writ petitions have been filed, or how many?
I have given you details.
3 details, but I'm counting and I'm not very sure. That's the petition 3, 1, 2, 8, 5, 6, 5. I think 7 have been filed, 7.
Yes, 13.
1, 2, 9, 1, 8. No, I think 8. 1, 2, 9. 1, 2, 9, 1, 8. No, 9 have been 8.
And what do you do?
My lord, assistant professor, now he is assistant professor.
Assistant professor.
My lord, in dentistry.
He is suppressing facts.
No, Lord, what happened, my placement? Initially, he went on challenging the appointment of the present appellant on the ground that he had suppressed the facts because he was not eligible. Thereafter, what happened when then all those cases were filed by him on that count. Subsequently, what happened when the question of promotion to associate professor post came into existence, advertisement was there, then he filed the present writ petition. In all the earlier cases, they were direct, the prayer was for direction to dispose of representation in respect to appointment of the present appellant as assistant professor. In 2000, this present writ petition, the fact came to the light that they were trying to appoint as associate professor, and so he raised that point, and in his claim, he said that in fact the present appellant was not eligible to be appointed as assistant professor. At page 106, page 106.
Related to associate professor.
No, not related to associate. No, not related.
Are you sure?
My lord,
What was the prayer in the first?
there is wrong.
Prayer is wrong.
My lord, that is why I give your lordship's kind attention to pages 14 and 15, because factually it is given.
Para 14 and 15 of what?
Of our writ petition, page 106.
Your writ petition,
106 may kind be. Page 106.
just a minute. So many writ petitions. So
Yeah, my lord, yes.
31258.
My lord, yes.
Para?
Para 14 and 15, page 106.
Page 106.
My lord.
Which can't be read.
Page
Annexure 9.
Para 14.
Annexure 9.
Yes, Annexure 9 is.
Annexure 9 can't read.
Annexure 9.
One 106 is Annexure 9, which we can't read.
My lord. Page 140. May I place it, my lord?
But how are you aggrieved by this order?
My lord,
How are you aggrieved by this order?
my lord, since that representation, which has been directed by the Honorable Single Judge to be considered by the opposite party number 2, OPSC, my lord, that representation has already been annexed to another writ petition, which is WPC OAC number 2350 of
See,
2018.
we can take any action against him, but there is no requirement of interfering with this order. There is
Again, I
nothing.
will be subjected to come before your lordship. He is dragging me time and again by filing this
So
multiple.
did you appear in those cases?
Yes, ma'am.
Had you appeared?
I have not appeared.
So therefore, why you are not being dragged? You are coming.
No, I am coming, my lord. He has filed multiple petitions.
You are
My lord,
dragging yourself to the court.
My lord, kindly see page 97, my lord. The
No,
certificate.
forget
which-
97. How are you aggrieved by this order?
My lord, thrice OPSC has been rejected his claim.
Again, they
By-
will reject his claim.
Rejected again, he will file the suppression of facts, all these repeats and filing
All
of
right,
this.
we
That will be covered up.
we can pass any order against him, but we shall not interfere with the order.
My lord,
There is nothing in the order.
my lord, kindly see page 97, the certificate which has been given. By the time the writ petition has been filed, the OAs which were pending before the learned tribunal were pending, and he has filed 2 writ petitions to transfer these OAs to this honorable court prior to filing of this writ petition. But he has not disclosed, my lord.
That is different. But what is there in the order which requires interference?
The same prayer.
My lord, yes, my lord. I am showing this, my lord, page annexure 4 to the writ appeal, my lord. My lord, running page.
So this order, this
My lord,
letter dated 12/4/2018 is on his representation.
Yes, my lord. Either the prayer
Where is this 12/4/2018?
12/4
2018.
annexure 4 to the, my lord,
Annexure 4 is copy of writ petition.
writ appeal 85, running page 85, my lord.
Page 85.
85. 24/2/2018, representation. That petition has been annexed to WPC OIC number 2350 of 2018. That writ petition was disposed of by the Honorable Single Judge, holding that the writ petition is infructuous, my lord. My lord, page 235. Order. Another coordinated Honorable Single Judge has hold that it is contended that by efflux of time, the writ petition has become infructuous. If that writ petition is infructuous, the documents which has been appended to that writ petition automatically may be infructuous.
What a logic.
My lord, self-same representation has been directed to be considered by the authorities in the present one. By the impugned order to this writ appeal, my lord.
No, but how does it affect you?
My lord, if these are the suppression of facts, if
Suppression of fact we can deal with, but how is he?
my lord, if again I will be in infructuous matter, my lord, again he will be again come to this court and I will be again.
No, he again means he has some remedy he is pursuing.
Remedy in merit also I am ready to argue, my lord. On merit also he is not
Where
entitled.
is the merit? Merit has not been decided.
Decided.
Where is the question of merit?
Again, my lord,
Since when is the representation pending?
pending, my lord, pending infructuous
No.
before the OPS, OP number 2, response number 2, my lord.
When?
Since 2018, my lord.
We will pass appropriate order. We will see, we will pass.
May I place only one matter, one line? He had been appointed as assistant professor.
Sir, we will not
My
go
lord,
into the merits.
I bow down.
We may comment on your conduct. We may pass an order imposing cost on you. We may decline to interfere with the order
Ma'am.
because of the nature of the order. How much cost would we impose? 30,000? 30,000. All right.
He has been out of appointment, out of service. Those things are also on record. I filed IH under affidavit.
All right.
Why is he out of service?
Because they are not allowing him to work.
Next.
Item 2.
I will be escalating. I will be escalating. I think 31. On the way of lost. I'm on the way of the cases.
We have posted to one date because she could not give instructions whether that.
No, that is paid. That is on the next date. Your lordship passed out on 7. We paid it from the.
No, she said somebody is ill in her family, so we have posted to 511.
3,17,000 orders have been paid on the 8th.
Item number 2.
May I please, Your Lordship? This is a PIL directed against the violation of law by the state authorities affecting a mass of Adivasi people. They are living there for last
So
3
you were not
generations.
there yesterday when the matter
Yesterday,
was called.
Lordship, I was outstation and the internet facility was not available there at. I saw
They have two associates, they don't come to court.
Lordship, I thought that the matter will not reach.
Oh.
It reached the.
We are appearing for the other side, yes? You are appearing.
Mother.
Lordship, let the
Affidavits have been filed.
Yes, Your Lordship.
Counter has been filed by the opposite party number 6 and 8 to 10, the chief engineer and those who are constructing the road. And by the collector also the counter filed. The allegation made in the writ application that these people are Adivasi and they have a forest rights, and the CDP comprehensive development plan published in the Gazette notification by the BDA has not been carried out, and they are unauthorizedly constructing the road. But this is a completely false first part, my
Lordship,
lord.
that
And there is no public elements is involved. Public interest element is
Allow him
involved.
to
It is a
I'll-
private interest.
I'll argue on
And this counter is very clear. What
Step counsel.
let the intervention application be allowed. I will implement. No problem. Lordship, this is a Gram Panchayat area. The affidavit of the Basti, they call it a Basti under BDA. But I file an affidavit that this comes under the Gram Panchayat area, and they are living for last 3 generations. In a
Which
clandestine
paragraph of the writ petition you have stated?
Gram Panchayat area.
Yes.
Lordship,
in all paragraphs is stated, my lord.
Mr. Counsel, please take your seat.
in all paragraphs I have stated, comes under Gram Panchayat area. Lordship.
All paragraphs. 4.2 it is not there. 4.3 also it is not there.
Lordship, 4.3.
Yes.
This unauthorized action result in road.
4 point is that however the integrity of this process.
Is transgresses into a Gram Panchayat area. Lordship, the left side of the road is a BDA
I am
area.
asking where have you made that averment?
This unauthorized action result in road encroaching upon petitioner's Gram Panchayat area. Lordship, 4.3 after Annex of 2.
Yes, got it.
And also, Lordship, in grounds I have taken. D. Lordship, at page 13D. Page 13D. May I place it, my lords?
Is there any commission for the welfare of scheduled tribes?
Department.
Is there any department, madam?
Patnaik. Yes, Your Lordship.
You have filed this affidavit on whose behalf?
I file it on behalf of the superintendent engineer, Your Lordship. Those are constructing the
Is
road.
there any social tribe welfare department or something?
Lordship,
Must
there
be.
is. Yes, Your Lordship, there is. But Your Lordship, we've taken the permission of the resettlement from the divisional forest
All
officer.
right, see, the petitioners are enforcing rights of the tribals.
Yes, Your Lordship.
You have already a department.
Yes.
There must be some corporation or commission to look after their
SC
welfare.
department is there, Your
So
Lordship.
they can take a stand. If they have any case, they can say. Otherwise, anyone can say and claim that he is representing the Adivasis. Let the department take a stand. Have you impleted ST
No, your
department?
lordship, they've not been.
Yeah, I think our department STSC backward minorities
Yes,
and
the
backward class
minority
welfare
and backward
department.
class, yes.
What is that department?
ST and SC development, comma, minorities and backward classes welfare department.
Department, State of Odisha, be imputed as party through its secretary in course of the day. So, Ms. Patnaik receives notice on behalf of the newly added opposite party. Stop. Next. Let an exhaustive counter affidavit be filed on behalf of the department addressing the grievances which have been raised in the presented application relating to scheduled tribe families in the forest area of Andharua Gram Panchayat in Khurda district. Stop. The added opposite party shall also be required to discuss the bona fide of filing of the presented application. Stop. Place this matter on 4 weeks. In the meanwhile, counter affidavit must be filed.
May I pray your lordship to allow me for 2 minutes?
So let the counter affidavit be filed.
That is mentioned already. Already it is available.
What?
Collector counter, annexure A by 13, page 7. May I place it?
Yes.
It is, first of all, it is not coming under Andharua Panchayat. It is not.
We are
Panchayat.
directing the ST department.
Second, so far as the SC and ST people are concerned, Gram Sabha was there and the forest diversion proposal was
Let him
there.
file affidavit. Let us see what stand is taken. The state government may say that what they are saying is correct.
But it is only I am placing that only. Nothing more I am placing.
All right, we will see after 4 weeks.
But the hurdles is, my lord, we are the private landowners. And so far as the road is construction, I have a very limited role. I will not demonstrate anything, my lord. We got the degree. Now execution court also directed to.
Is there any order against you?
But there is no order.
In this case?
When we approach to the police, that after the civil court order, we have deposited 3,20,000 for deployment of force. The police said, because of pending of this PIL, please wait. We said
that just a minute. We should pass an order that the police should not say this.
No, legal. There is no legal impediment.
Legal. If you have any grievance, you can raise before appropriate forum, not here.
Here, our predicament has to be.
Predicament. We are not here to address predicament. We are here to decide matters.
Lordship may dispose of for the
what
counter affidavit filed by the collector and the department.
We should dispose of the writ petition.
What?
We should dispose of the writ petition in view of the counter affidavit.
Yes, my lord.
The order which I passed, is incorrect according to
my intervention application may be allowed. No objection has been filed.
All right. Intervention application has been filed. Posing the prayer in the present public interest litigation on the ground of the private rights which the interveners have in respect of the land in question. Stop. I number so and so is allowed. Necessary there, they will try to think.
One day here,
kind enough to go. They use page 63 and 64 of the writ petition regarding performance security, and page 63 speaks of performance security, my lord. And this page 64 also speaks of a performance security with an additional cause of additional performance security, my lord. So I will not take your lordship anymore there, my lord. Then I draw your lordship's kind attention to page 44, my lord. Has your lordship got it?
Yes, please.
Page 44, 2.1.3, my lord. Has your lordship got it? May I place it?
Yes.
Notwithstanding anything to the contrary, contained in the RFP, that is request for proposal, the detailed terms specified in the draft EPC agreement shall have overriding effect, my lord. This draft EPC is annexed along with this tender notice, my lord. That is at page 112.
Yes. Close seven.
Has your lordship got it?
Yes. 112.
112, my lord. So, this 7.1, my lord, performance security 7.11, and till the extension of the performance security, my lord, appropriation of it is a performance, there is not a single mention of this assistant additional performance security, my lord. Then, my lord, the contractor shall, for the performance of its obligation hereunder, provide to the authority within 30 days of the issue of a LOA an irrevocable and unconditional bank guarantee for an amount equal to 5% of the contract price from a bank in the form set forth in Annexure 1 of the Schedule F. Then that is nothing, my lord. I have scanned, my lord. I am not wasting your time, of lordships, but your lordship can take my statement that additional performance security of 10% is not spelled out in Article 7. Then another page, my lord, that overriding effect of the EPC, my lord, 109, my lord. Has your lordship got it? That 1.4. This agreement and all other agreements of the documents forming part of a referred to in this agreement are to be taken mutually explanatory unless otherwise expressly provided elsewhere in the agreement. The priority of this agreement and other documents and agreement forming part hereof are referred to herein shall, in the event of any conflict, be in the following order. A, the EPC agreement. So that EPC agreement has been given much more importance than any other documents in the tender call notice. But then I was placing that decision yesterday. Lordship, kindly bear with me for another 1 minute. May I be permitted to place paragraph 22 to know what was the case about? Has your lordship got it?
Just yes.
The 22, my lord. The tender conditions contained in clause 8.2 relied upon by learned respondent number 2, GMVN, and in clause 9.8 relied upon by the petitioner at loggerheads. In as much as while clause 8.2 states that the H1 bidder is obliged to deposit the requisite amount within a week and complete the formalities to start the mining operation from 1st October, clause 9(8) in clear terms states that the successful bidder would have to deposit the bid amount within 1 week of the execution of the MOU. It further states that the amount to be deposited towards the first installment would be 1/9 of the total amount due from the contractor. So far as the clause relating to submission of performance security is concerned, which is contained in clause 9(2), read as follows. सफल निवेदिता द्वारा प्रतिभूति के रूप में लूट हेतु निर्धारित 1 वर्ष की रॉयल्टी की बराबर की धनराशि की आंकड़े और एसटी और गारंटी जो राष्ट्रीयकृत बैंक द्वारा जारी 5 वर्ष की अवधि हेतु प्रबंध निर्देशक गढ़वाल मंडल विकास निगम के नाम पर बंधक तथा बरामद रखेंगे. But that is the preference. This clause doesn't state as to when the performance security would be required to be furnished. However, it is natural that the performance security would be required to be furnished only when the MOU is executed between the contractor and the GMBN. The tender in question has been issued by the GMBN. It is the GMBN who is the author of the terms and conditions of the tender. Since there is a clear contradiction in the aforesaid clauses, namely clause 8(2) and clause 9(8), and there is no clarity due to the confusion created by these two contradictory clauses, the doctrine of verba Chatram 40 appellanta contra referendum would be attracted and bind the respondent GMBN, and the tender document is liable to be construed against the respondent number 2 GMBN. And that's all. Good. Well, that page 64 can be only 1 minute. 221(2). Here, let's see, make kindly class. Page 64, that where that additional performance security is spoken of. 221(2). Has your lordship got it?
Yes.
For detailed provisions of performance security and additional performance security, refer Article 7 of the draft EPC agreement, which is at page 112. 112. Which I have placed, my lord, which doesn't contain anything about additional performance security. That's all.
It's just right.
Clause, that is performance security, is in 2 pages. There is a repetition of regarding in 2 pages. That is the internal page 32, running page 63 and 64. And regarding that, I have already admitted in my counter that this is an inadvertent publication of the bid document that has been uploaded in the technical notice. But I have lots of the last occasion I have given the EPC, the engineering procurement and construction mode, the document I have last time given, as well I am submitting the whole of the bunch, which is the standard document since 2019 and 2021, and that is applicable in all the cases where the tender is floated by the government department.
That means
EPC you have quoted here.
Lordship, there is a difference between performance security and additional performance security.
no. Was that clause there in those earlier?
Yes, my lord. It is there in the original page.
No, not original. I'm saying the earlier things which you are relying upon. It was there.
It is there. It is there, but this is an inadvertent uploading,
Yes.
which is not there. And this is not only in the stand and the counter as well. It is the reply to the representation of the petitioner who is filed before coming to this honorable court. You may kindly see the speaking order that has been passed by the concerned authority at Annex 9, page 138. It has been written that it has been wrongly uploaded, but this does not curtail the additional performance security, because there is a reason behind it, the issuance for asking for additional performance security.
See, Mr. Counsel, reason is different.
My lord.
The question is that you are bound by the terms as disclosed in your tender notice.
My lord.
All right.
My lord.
So whether based on the tender notice, you can demonstrate that additional performance guarantee was required. That is the question.
It was there. In the tender notice, both was there. It is a continuation, your lordship.
No. It was there in that second page.
Yes.
Is there any other clause or any documents in the tender document from which we can ascertain that this is part of that?
Yes, your lordship.
Confusion has been created by loading of
It is not confusion. It is, in fact, the confusion is with respect to uploading. That I have admitted in my counter.
Your part, the person who reads,
Yes,
how will they know that it is a confusion or deliberate or that is the part?
No, it is because I have given the original document, your lordship. It is the standard EPC agreement, 2019 and 2020.
Subsequently, but can the bidder know from the documents which you have?
Yes, my lord, because it is standard procedure that is followed in almost all the cases. But not a single case that is left out where there is a reason of performance security and additional performance security. And the reasoning has been given in the next page, your lordship. That is also uploaded. My lord, may kindly peruse for a moment. The same page 64,
Yes.
what is being praised by my lord Senior. Performance security, it is an estimated cost for the project was 263 crores. And your lordship, they have quoted 197 crores. Now, your lordship, from the page 64, that has been relied upon by the petitioner itself, I will try to convince your lordship and present my case that both are part of this tender process. Lordship, for a moment, kindly see 2.21. If your lordship permits, I can read it out. What is the purpose of performance security and additional performance security? And the first part, 2.21.1, page
Where are
64.
reading?
Page 64, your lordship, read petition. Page 64, this same page relied upon by my lord Senior.
Yes.
Yes. Within 30 days of issue of LOA, the selected bidder shall furnish to the authority an irrevocable and unconditional guarantee from a bank in the form set forth in draft EPC agreement, that is performance security, for an amount equal to 5% of its
You are
bid
reading
price.
which clause?
My lord.
Which clause you are reading?
Clause 2.21.1, page 64, your lordship.
Yes.
It is only a repetition of the previous page. Now, up to this point, it has been given in the previous page. Now, this comes the complete clause that I have already given to the total agreement, total APC agreement. In case of accepted bidders, value is less than 90%. Now comes the additional performance security, your lordship. In case of accepted bid value is less than 90% of estimated project cost, the selected bidder, along with the performance security, shall also furnish to the authority an irrevocable and unconditional guarantee from a bank in the same form given in the draft EPC agreement towards the additional performance security for an amount calculated as under. Now, also this calculation, before I going to go to this explain this calculation, your lordship, the very reasoning is an estimated cost is given for a project, particular project. Suppose it is 100 rupees, or as it in this case, it is 263 crores rupees.
All right, you are not required to, you have to read just.
Your lordship.
Just the
next part, if the bid price value offered by the selected bidder is less than 90%, but up to 80% of the estimated project cost, then the additional performance security shall be calculated at the rate. This is now talking about only additional performance security at the rate 20% of the difference between 90% of the estimated project cost and the bid price offered by the selected bidder. If the bid price value offered by the selected bidder is less than 80% of the estimated project cost, then the additional performance security shall be calculated at 30% of the difference between 90% of estimated project cost and bid price offered by the selected bidder. Now, the additional performance security shall be treated as part of the performance security. This explains performance security text within it, additional performance security, for the reason that because in the present case, the bidder has quoted, the petitioner quoted 7.502%. If the project cost is 100, then she has quoted 75 rupees. Now, in the counter, I have explained it, that why it has been given. It is only given for the reason is, petitioner contractor has quoted 24.98% less than the estimated cost. Hence, the bid price comes to 197 crores against the estimated cost of 263 crores. This additional performance security is only imposed in those cases or triggered in those cases when the project cost is, the tender project cost is less than 90% of the estimated project cost. And it is only for the reason, Your Lordship, to secure that the bidder or the contractor, while performing a public nature job, should not flee away after 1 year or whatever the project period is there, and there is not a loss to the government exchequer. In the counter, if my lord may kindly see for a moment, I've explained it for a reason that this additional performance security only comes when it is the quoting by the bidder is less than 90%. If it is within 80%, then it is 20%. And if it is within 70%, then it is 30%. In the present case, as he has quoted 70.02% of the estimated cost, that is 24.98% less than the estimated cost. That's why, along with performance security, additional performance security has been asked to be paid. This is the only reason also. For a moment, if your lordship may permit me to read page 152, running page 152 and my counter, where I've explained this. For a moment, your lordship, I only beg for 2 minutes so that I can conclude that why this reasoning has come up. Admittedly, I have nothing to, I have no hesitation to admit that in page 63, there's an inadvertent uploading. But page 63 is not the complete one. The complete one comes at page 64, which is there in the uploaded part along with the page 63. So page 64 is to be taken into consideration, and this is not only a stand in the counter, rather it is also a stand in the reply that has been given to the petitioner when he filed a representation objecting to the additional performance security.
Yes.
Now, my lord may kindly permit me to read one paragraph of my counter affidavit. Page 152, running page 152. Here I have specifically admitted what is the reasoning and why we are giving it.
Yes.
With a permission, my lord. That in this regard, paragraph 21, your lordship, it is to state that clause 2.21 at page number 32 of the RFP, annexure 1 to the writ petition, is applicable for those bid price which is above 90% of the estimated project cost, and clause 2.21 at page number 33 is for those bid price which is less than 90% of the project cost. In the instant case, petitioner contractor has quoted 24.98% less than the estimated cost of the project, that is 263.32 lakhs. Hence, the bid price quoted rupees 197.54 lakhs is less than 80% of the project cost and comes to 75.02% of the estimated cost. Accordingly, this attracts additional performance security of 30% of the difference between 90% of the estimated project cost and bid price of. Thus, as stated in the letter of acceptance, the deposit petitioner has to deposit a sum of 11 crore 83 lakhs and 36,000. Now, your lordship, I have already admitted that at paragraph 23 of the next page, your lordship, page 154.
Yes.
My lord, the petitioner taking advantage of the inadvertent uploading of a part of clause 2.21 at page 32 of RFP. I admit that one part inadvertent has been uploaded, but that is not there in the EPC that I have submitted before this honorable court, because this is issued in 2019 by the Ministry of Railways, and that is the standard. Every project cost or work or nature of work, whatever, the description differs, but the condition always remains the same. For a moment, the EPC I have already submitted, my lord kindly sees. That is issued by Ministry of Railways in 2019. It cannot be changed pursuant to a particular case, your lordship. This cannot be changed. In the EPC I have last time submitted. My lord, can kindly see this one. It's my copy. I have submitted. Please have it. I have given the copy to the this one.
Yes. Yes, it is there.
My lord, kindly see in the original document in October 2009 and corrected up to 2020, since 2020 up to 2024. Whatever conditions railway tender projects are being issued or floated, that is as per this standard module, these standard conditions and review. Your lordship, kindly see internal page 30. If your lordship is holding the EPC, I have already submitted the original part.
Yes.
Page 30, your lordship. For a moment, if your lordship kindly comes down to page 29, after clause 2.20.5, there is no second clause of 2.21 as has been given in this particular tender document. I cannot deny, because it is on the nature, and before this honorable court, I cannot say that this part in page 63 was never uploaded. It was uploaded, but it was an inadvertent mistake because it does not carry the whole of the condition. The whole of the conditions comes at page 64, that is clause 2.1.1. That's why there is a repetition of same clause at 2 pages. Now, my lord, may kindly see the original part. It is since 2020 and it is valid up to 2024. On this date, we are arguing this matter, my lord. This is the original one, 2.21.1.
Just a minute, Mr. Kashyap. You're relying on page 64.
Yes, your lord.
So you're relying on the clauses in that page.
Yes, lord.
So look at 2.2.2.
Yes, ma'am.
It is different from that clause in the
No, your
previous
lordship.
page. Please see and then.
2.22. Let's see.
2.21.2.
Yes, let's see.
Yes.
For the detailed provision of the performance security and additional performance security, refer Article 7 of the draft EPC agreement. Today itself, the bulky volume I have just passed.
No, it is all right. But Article 7, which is there in that,
My lord,
that relates only to performance security.
it is related to only performance security.
Yes.
Because it comes when it is only within 90%, the estimated cost or project cost
Why
offered.
did you say Article 7?
Article 7, they have also annexed at page 112. I have also given the original part.
Yes.
The bulky volume.
So that refers only to performance security.
Yes, dear lordship.
Yes.
This refers to only performance security when it
Not
is
additional performance.
not additional performance security.
Yes.
Only additional
2.1, 2.2. What does it say?
2 point, dear lordship, 2
The
point.
one which you read.
Yes. It says about additional performance security.
Yes.
2.1.1.
Refer to Article 7.
Article 7 is only about performance security, your lordship.
So how can they get details about additional performance security?
Let's see, there is a difference between these two EPC. EPC is one part, and this document today passed on to your lordships. It is the standard engineering procurement.
No,
It is the request for
was this standard EPC
Part of that.
was referable to the tender notice?
Yes, lords.
Whether anywhere it is mentioned in the tender notice that the requirements of EPC or standard that will have to be seen or referred to while is it there in the tender notice?
It is there, your lordship.
Where?
It is with all the 2.1.3, as my learned senior has already placed that. When there will be a difference or anything, then the standard EPC will be referred to.
Okay, where?
2.1.3, your lordship, page 44. 1.3, page 44. That my learned senior is already placed. Not, your lordship, page 44 of the writ petition itself.
Yes.
My lord can also refer to the part I have already given in today the standard format.
Operating effect. All right.
What your lordship is searching is there in page 41. 41.
2.1.3, 41.
Another clause is 1.1.4. Draft EPC agreement set forth the details, terms and conditions for award of the project to the contractor, including the scope of the contract service and obligation. This is in the instruction to
Page 41.
Yes.
All right.
Only one word in reply. Only about that expansion, that where it exceeds 90 lakhs or other things, additional purpose.
Below.
My lord, I didn't say they go this case to Mahendra Singh's Gill, my lord. what has not been there in the document cannot be improved by the way of filing counter.
No, they are not improving that. They are just relying on.
The object that has not been.
No, object is not required. If it is part of the notice, part of the draft EPC, then whether.
It is not a
You can
question
find
of the
that.
draft. If additional performance is not there in the draft. I have shown it to your lordship in Article 7.
No, please show. It's
Even-
not there. in the
even-
draft
Yes, it is
EPC.
there. Your lordship, two things are there. One is standard EPC,
No,
one
that
is draft EPC. In draft EPC, it was there. Both the conditions there. One half placed, other one completely. That's the difference.
Article 7, my lord.
Article 7 of the EPC, draft EPC says,
Doesn't say about
doesn't say about anything.
additional performance.
No, that we have seen.
That we saw, but he
Yes.
says
But by any chance, it is their document.
standard.
They have supplied the complete one at page 64.
Yes.
This is only additional when the performance security comes less than 90%.
Yes,
My lord.
this clause will not be attracted if it is
Exactly,
more than
yes.
90%, clause will not be attracted. So this is, can be said additional performance security, additional clause also.
Yes.
But how will they know?
Yes.
It is there, your lordship. It was there. It was uploaded also. It was there, page 64, it was uploaded.
Oh, page 64, it's all right.
My lord,
So page 64 refers to that EPC.
like lordship.
Where is that?
And as well, it takes with the additional performance security. Article 7 is a standard prospectus. RFP is particularly for a project. Whatever project is floated.
Yes.
Both the documents were uploaded. One partly, one.
Oh, again, documents you are saying.
Yes,
Those
both have been
pages.
2 pages, your lordship.
Pages.
Same clause, 2 pages.
So
One,
what
it has
is-
been inadvertently half. Yes, that is. And there, the petitioner is trying to take advantage of that only.
Why should he not take advantage?
Let us say, my mistake, I should admit that.
Whether mistake is genuine or not, we are
This
trying to
mistake
find
is genuine or not, your lordship, this can be ascertained from the EPC that I have submitted, the standard form by the
With
Ministry of Railways.
this document.
Your lordship, the smaller one, the last time deposited,
Okay.
submitted, your lordship. That is the engineering, this is a standard engineering procurement and construction since 2019. Your lordship sees. It is internal page 30. Let's me kindly see for a moment. There is no 2.21 repetition.
No, but was this available for them?
Yes, it is available in the Ministry of Railways website, your lordship. I have downloaded from the website.
Accessible to
Not
everyone.
in the tender document.
No, it is accessible to everyone.
Tender document, but if they refer to that.
This is a standard document and this is also relied upon by them.
All right, we'll see, we'll
From
decide.
27 to 30, your lordship sees even this document, this doesn't speak of anything additional performance.
Okay, let's see for a moment. If I am mistaken,
I cannot understand.
page 30, your ladies. Page 30, your ladies, that I have submitted, Ministry of Railways. Yes, it is the same thing, your lordship.
I am asking for detailed provisions of performance security and additional performance security. Refer Article 7 of draft EPC agreement.
Article 7 is only about performance security, ladies.
So why have you said additional performance security? Refer
In
Article
the-
7.
That is for additional performance security is a part of performance security. For that performance security, you can refer Article 7. Yes, your lordship, 2.21.
Yes, read it.
3. The additional
How
performance
do
security.
you deal with this 2.21.1? Mr. Mohanty? 2.221.1 at page 64?
64 Miller.
It was not there. It was there.
It was there, this was there, Miller. Miller, what I am trying to persuade your lordship is that does it create a confusion in the mind of the bidder?
That this does not create any confusion in the mind.
Read with 63 and 64, Miller.
Yes, sir.
Whichever is beneficial to the bidder would naturally take consideration.
Again, there are Supreme Court's decisions that they are the best persons to
Interpret, my
to
lord.
construe.
And not after having committed a mistake, my lord. I don't think
that is not
any
a- that is-
petitioner
that is-
will
No,
that
no,
is-
mistake also they can go back on that mistake.
My lord, exactly that I showed to your lordship that there was a mistake in that also, that decision also.
All right, we may differ.
That is up to your lordships. My,
But
my,
64 is.
my job is to persuade your lordships, and for interpreting 64, I am telling that, my lord, your lordships, why not your
See,
lordship will refer
do
to.
you want us to ignore 64 altogether?
No,
Because
no,
of
no,
63?
my lord, for detailed provisions of performance security and additional performance security refers Article 7 of the draft EPC agreement.
All right.
Admittedly, in this Article 7, there is not a single word about.
May not be, but it is very clear. It is.
Then this clause,
Mr.
both in
In what, how can we ignore this? What is there in 2.2.1?
See, is 63 also speaks for detailed provisions of performance security, refer Article 7 of the draft EPC. Then 64 also says that for detailed provisions of performance security and additional performance. When there is a contradiction, my lord, about the absence of the additional performance security, my lord, I will go to the draft EPC, my lord. That is what I am trying to persuade your lordship.
Yes.
The petitioner willing to deposit additional performance security if granted the time.
I am a businessman, my lord. If you
No, no,
are
I'm asking because let us say some confusion he did not grant, but that is necessary in view of that clause. So are you willing to
if
deposit?
your lordship is going to hold that I have to give, I will give within a stipulated time that your lordship. What is the? But I am a contractor, not today. I am a contractor.
And as
with
the
them
lordship, it's a
for-
security amount, it will be reverted.
Exactly, because let us say some confusion, so has not given.
My lord.
But if, I mean, that is part of the
Performance security.
performance he has to give. And because of that confusion, he has not given, whether he should be granted time to.
Your lordship
As
has
your lordship
authorized, granted interim order also.
Here he is protected by the interim order, as your lordship decides.
The lordship gives me a reasonable time, not because 10% is a very hefty amount, 11 crores.
Nothing for you.
round of litigation of them. The second
Nothing for you, for your client.
Second round of litigation.
Yes.
What are you saying, Mr. Party? Second round?
Yes, lordship.
Yes, first.
Initially,
First time we have filed, then second
Back to the
We have
authority.
maintained all transparency, my lord. We have not.
Second round means your lordship asked them to take a decision in terms of that draft EPC. And then they also stopped to that.
Oblige, my
Tuesday for judge.
Oblige.
Your lordship will kindly take into consideration the amount and the income.
How much time, Mr. Party? What should be the reasonable time?
As your lordship decides.
I leave to the court, my lord. Lordship's convenient.
1 month?
30
Yes,
days.
yes.
30 days?
Yes, yes.
30 days, we can.
Yes, oblige, man.
Item number 4.
Item 4, my lord. I prayed 1 week time may be granted for filing rejoinder. 1 week.
1 week.
43 also is the same.
Yes.
Item 43 is also the same.
We are for the Minister of Ayush.
43. Maybe tagged up together, all the three.
They mean additional performance security.
No.
Admission.
Admission. I'm sorry, madam. I'm not in that league.
Huh? That is-
I lord, interim order to continue on item number 4.
Yes.
Interim orders may continue. They're studying if they're in.
Yes.
This admission item number 5.
So, I do my lord, in this case, I am appealing for respondent matter.
Yes. Did you get the money?
No.
Condonation of delay?
2 weeks time may be granted to file objection.
What is the delay?
But delay 174 days.
174 days we can. What is the dispute about?
Dispute that Narsu Pradhan judgment. Now, the entire NMR period and the work charge period have been directed to be counted for the purpose of.
We are taking up those matters, madam. So we can condone the delay and hear your case on merits. 174 is nothing. And even if we do not condone, they will get it condoned. We are condoning it, 10,000. All right. 10,000. 10,000, mister.
There are two cases. Both the cases.
So
5,000 each.
Well, have you filed your?
Today I filed my book.
Yeah.
Report.
File in the registry.
Fine.
Accepts.
Allotment.
So these are-
Okay.
5,000 each.
5,000 is all right. 5,000.
Each.
5,000. To the petitioners, to the opposite part, respondent.
How many respondents? Sole?
Sole
Then
Sole respondent in both the cases.
In both the cases, one and.
First, they are dispensing with the report, then condemnation of the again defect.
Is there any defect?
The SR is not, bill is not paid for. So note and give it. Okay. Put it high usually first page.
This note,
Who page?
just digital page 6.
Running page.
The next is not attached.
Still not attested, not prayer made. This can't be done, prayer made without signature. Just to remove.
This is subject to removal of the defects within one. And also subject to payment and also subject to removal.
Mr. Saswat Das, an additional government advocate, undertakes to remove the defect pointed out by the stamps reporter within 1 week. IA for dispensing with filing of certified copies. When will you file certified copy?
Certified copy, my lord, grant me
You filed since last year.
weeks
Yeah,
time.
yeah.
2 weeks time maybe grant.
IA Das, an additional advocate, undertakes to file the certified copy of the implement order. Is it a common order? No? No, not a common order.
Not a common.
Within-
Separate.
Then IA is accordingly disposed of. IA 1711/2023 is the delay of 175 days. Filing of this writ appeal. A full stop, this IA has been filed for condemnation of delay. Third Learned Council for the parties. Considering the grounds taken for the IA. And so in the interest of justice, we are inclined to condone the delay. Filing the writ appeal, subject to payment of cost of ₹5,000 to be paid to the we paid to the respondent within 2 weeks.
2 weeks.
Within 2 weeks from today. I is accordingly allowed in court of subject to payment of cost and removal of defects.
Defect.
I is accordingly allowed and disposal. Same order in second one, only thing delay. Yeah, that is, this also 176 days. Okay?
Yes.
All right. Council Mr. Babita Kumari Patnaik. And one more line. Ms. Babita Kumari Patnaik, learned counsel, submits that she has instructions to appear on behalf of the respondents in the description in the bill. And shall file Wakalatnama, the registry in course of the day.
Item number 6.
Here's what happened.
My lord, my instruction is it could not be settled.
My lord, in fact, he visited the last on the 21st of October and he requested for 3 installments to be cleared within 3 months. Then we suggested that it can be cleared within 30 to 45 days. Then he said that, all right, I will intimate you within by 3 o'clock on that day, but thereafter he didn't turn up.
What is the amount?
71 lakhs 85,000.
How much time will you take to pay?
My lord,
How much time do you need to pay the amount?
my lord, we my client met the officer and the requirement was according to the schedule as per the order passed by the Honorable Court. That was coming to around 51 lakhs. They said that it should be 71 lakhs. I said it will be 51 lakhs. I am agreeable to 51 lakhs. There is no difficulty, sir.
All right. Let us see the order then.
My lord.
That extra 20 lakhs include interest.
Pardon?
That extra 20 lakhs include interest.
My lord, your lordship suggested that what should be the price of the flat as on date. So we have taken the evaluation from 3 valuers and we have come to an aggregate that it will be around 71 lakhs and 85,000 as on date. And that is why we have submitted with your lordship. And your lordship also has reflected this in the order previously. Thereafter he said that, all right, I will take instruction whether my client can pay that money or not.
Yes.
My lord. The allotment of flat was, my lord, here the flat was allotted pursuant to the on July 2010. So as per the terms and conditions of the procedure, he has initially deposited 50,000 towards the registration fees, and after allotment of the flat, he was required to deposit 20% of the amount. The price of the flat at that time was 47 lakhs.
What is wrong with the order?
But
See the order.
because he didn't, we have communicated that you have to pay 14 lakhs and somewhat. And we have reminded also, given reminders.
No,
You are challenging an order.
What grounds?
My lord, I am placing it, my lord. And since he has not deposited the amount, we have cancelled it. And we have cancelled the allotment on 6th of September 2011. And thereafter, my lord, he have made representations saying that some time may be given to me so that I can arrange money and deposit the amount. And he has been going on submitting representation. And we intimated him that since we have already taken a decision for cancellation, we cannot do anything. Better you can approach our higher authority. That is under Annexure 12, that is of the writ application. That is 28th of July 2012. My lord, thereafter he came before this honorable court and filed this writ application in 2013, saying that the cancellation of the allotment is not correct and I may be allowed to deposit the entire money with 6% interest. And the honorable single judge took this letter dated 28th of 7, 2012, that since you have already intimated them that you can approach the higher authority, that means the cancellation order has been again revived. So better you Thereafter, my lord said that all right, you take 6% interest and
Can you pay 61 lakh?
My lord,
Can you pay 61?
my lord, 61 lakh will not come in any way, my lord. My lords can have a look to the
All
order.
right, we will decide on merit.
My lord.
and my lord.
We will decide on merits.
Yes, ma'am.
Try to resolve it. We are trying to resolve it. Yes.
Yes, my lord, your lordship may kindly see the impugned judgment that starts from the conclusion transfer paragraph 13. May I place, my lord, paragraph 16. Paragraph 15, I will place. Though the pleading in this court again finds for finding no answer for the opposite party to for a long time, the petitioner went on making further correspondence, even reminders, as appearing through annexure 10 and 11 series. In the meantime, it also appears from annexure 12, a letter issued by the
Mr.
executive
Raj,
director.
have you asked your client if he can pay 61 lakhs?
My lord.
Your client is not agreeable to pay 61 lakhs. He wants to pay 52 lakhs only.
My lords, according to the.
No, forget it. We are not saying
Yes,
how
ma'am,
you have a right.
51 lakhs.
62, yeah, we won't. All right.
My lord. Then page 12 of the running page 20 of the writ plea, that is the impugned order, paragraph 15, my lord. My lord has referred to the communication which we made on 20th of July, and it quoted this. It is to inform that as the matter has to be dealt with as per the prescribed procedure, you are requested to contact our Deputy Chief Engineer, LIC of India Divisional Office. This is certainly a development taking place on 20th of July 2012, after the cancellation order at Annexure 8 issued on 6/9/2011. It is again after receiving this letter when the petitioner contacted the opposite partner 2, there is clear pleading by opposite partner 1, refused to keep the request of the petitioner on the premises that this matter has already been referred to the head office. Then, my lord, the subsequent paragraph, my lord has said, paragraph 17, but here the development, I am reading 1, 2, 3, 4, 5 lines from the bottom, paragraph 7. But here the development through letter dated 28/7/2012 cannot be lost sight of. The matter was definitely kept alive. Further, also bringing by way of objection that the petitioner did not respond to the repeated correspondences of the opposite partner 1 by annexure such and such and such, and claiming that the petitioner is suffering from his own inaction. There is, however, no denial of the contents of the petitioner, showing his readiness to deposit a sum of rupees 4 lakhs. In one of the letters, he said that I have already arranged and I am submitting the Xerox copy of the demand draft. But in fact, there he has said that I am arranging money. Please give me some time to deposit the amount. So, the Honorable Court, referring to this letter only, said that since you have kept this matter alive, so as per the terms and conditions in the brochure, that is paragraph 13, you settle this by taking 6% with. But he referred to, my lord, clause 13, 1C. That is quoted also. The clause is also quoted in the impugned judgment. The lordship may come to paragraph page 24. In respect of allottees who decline the allotment or fail to respond to the allotment within the prescribed time, the total registration charges of FITLE will be forfeited. In respect of allottees who have accepted the allotment or paid the first installment but fails to pay the balance subsequent amount within time schedule, as mentioned above, and as per the intimation by the LIC, the registration refunded without any interest. In case any payment is not paid within the stipulated period, the allotment is liable to be cancelled. Here, my lord, since after the allotment, he did not pay the first installment, and we have given him the letter asking him to deposit the sum. Despite reminders, also didn't deposit. Therefore, the cancellation was made. So there is neither any arbitrariness nor any illegality, because he bound himself with the terms and conditions of the brochure. Now, referring to that, this Honorable Court said
the readiness of the petitioner preparing the bank draft even prior to the date of cancellation. Further, for the correspondence of the own dated 20th July 2012 by the next 12, this court finds there is no doubt that the case of the petitioner was kept pending consideration at least till 28/7/2012. Well, in fact, it was cancelled since 2011. And this was only a communication since he has been going on making representation. We said that all right, you can approach the higher authority because we have already cancelled it. For the pleadings of both the parties, the court finds that there has been no further communication to the petitioner after the assurance given to the petitioner through Annexure 12. No assurance was in fact given under Annexure 12, my lord, on the operation of the correspondence, on the operation of the correspondence at Annexure 12. And in the information therein came to the existing. For the opinion of this court, there is automatic non-operation of the conciliation letter.
What is
issued by
what is the amount according to this annexure, this order 24, paragraph 24? The interest at the rate of 6%?
That will come around 43 lakhs.
No. We made a calculation, my lord. That will come around 26 lakhs.
We are not inclined. We shall dismiss the writ petition. We are inclined to allow the appeal. Because since it's an agreement, you did not fulfill. It's over, matter is over. Where is the question of representation at this time?
And my lord, to that effect, I have submitted the judgment of the Honorable Apex Court in 2018, 19.
We will.
And that was
we will
also followed by
interfere
subsequent judgments of the Honorable Court.
May I place my lord?
Borelli Development Authority. I have submitted.
Judgment is there.
I would. And the said judgment of the Honorable Supreme Court has also been subsequently followed by the Delhi High Court as well as the Allahabad High Court.
We shall interfere. Considering the facts and circumstances of the case, and in view of the nature of order which was passed by the learned single judge, which is impugned in the present intra-court appeal, we had made attempts to get the dispute resolved amicably. To stop. Learned senior counsel appearing on behalf of the petitioner has stated, respondent has stated that in no case the petitioner shall pay more than a sum of rupees 51 lakh.
What you are saying, you will not pay more than 50?
I'm minus 51 lakhs.
51 lakh. To stop. Is the stand of the appellant that the appellant is said to have offered a transfer of the flat in question on payment of, in favor of the respondent on payment of 71 lakh. To stop. The dispute thus apparently could not be resolved amicably. To stop. You have heard learned counsel of we had indicated as to whether the petitioner can pay a sum of rupees 61 lakh in place of 71 lakh as offered by the appellant to give a quietus to the present proceeding, learned senior counsel has answered in negative. Stop. Heard learned counsel for so and so. On merits, list this case for judgment 2 weeks. Yes.
Item 7.
Already complied.
With.
Item number 8.
In this case, notice has been issued. Someone has appeared.
So Samantrai, where is it?
Jitendra Samantra and H.C. Das. On last occasion, he has also appeared.
Last date he was present.
On 2nd September, he was present.
Why was it urgent?
Your Lordship condoned that delay
For fresh admission.
come for fresh admission.
It's a notice. It's a notice.
Already my notice has been issued.
On the
Your Lordship-
limitation matter.
Yes, sorry.
The
Sorry.
limitation, notice was issued in limitation. Not in the main.
Sorry, ma'am.
All right. Tomorrow,
Yes.
there is no representation on behalf of the respondent. This matter tomorrow. Yes.
Item 9.
Nine, I have appeared for the respondent. I need, I pray that let one rate application, namely WPC number 12,563 of 2024 be tagged to this case because there is some development after this order was input was passed. And they said that as the honorable single judge didn't hear them, but they have, that was carried out in that. And again, this rate application was filed 12,563 of 2024 by the respondent. And they filed, order has been passed there. And as to that effect, I want to also file an objection to their averments.
No, they are challenging an order. How do you support that? That is the question.
You're saying the respondent has filed another writ application?
Yes, thereafter. They have challenged that this application was the present appellants were not heard. Thereafter, they complied the order, but didn't give the reappointment order for, so that another writ application was filed before this honorable court, 12,563 of 2024.
This order has been complied.
Yes, there.
How do you say they complied with the order?
That I want to give the objection. So let that matter be tagged. The writ application 12,563 of 2024. Let the matter be tagged and I file.
They are challenging this order in at page 37.
Let that matter may come. Everything.
This order is under challenge.
Let's.
This order has been complied with.
Partly complied with. They challenge that assistance. This honorable court directed the present appellant number 3 to submit the fresh application according to 1990 rules. The assistant, the appellant number 3 said.
You are the appellant.
No, I am the respondent.
Then why are you saying appellant number 3? Who is appellant number 3?
Appellant number 3, my lord. The assistant director of sericulture.
Those orders are there in subsequent writ application.
This is not permissible, Mr.
I will file
an order which was challenged was set aside by this court.
Yes.
Without issuing notice. How is that possible?
And the Malayananda City case, they have that was
What is Malayananda City? For whatever, for the smallest thing, you will have to tell the other side. Some opportunity is required to be given.
My lords, give me some opportunity. I'll file an objection.
We are giving you opportunity, but did you give him opportunity?
That will be decided, my lords. Let me press the subsequent developments.
What subsequent development? Subsequent development, the legality of the order is to be tested.
Millers.
Not the development.
Millers. I have done. I'll file an objection to it.
Objection to writ appeal. You accept notice, we can adjourn for
I have
for you
accepted
to
notice.
consider
I have
and
accepted
address
notice.
the court on merit.
I have accepted the notice. Your lordship, give me one chance to submit the place. Or let him submit. I will
say the order has been set aside.
To consider the application.
It is similar to item number 8, but
Yeah, we will not pass any adverse order against you. It is not that we shall
yes,
dismiss your
8 and 9 are
petition.
the same issue. 8 and 9 are same issue, as my learned friend was saying. But they are challenged that they are not being heard. So when they are not being heard, how could they comply with that order?
Not being heard, comply with the order means? That means they've been heard. They've been given a chance of hearing. Does it mean that when the order has been passed on the first day?
Yeah, let's see, give me a chance.
All right, we will decide.
8 and 9 same date. That 8 M. Let's see was adjourned to 9 and
Counsel Learned AG appearing on behalf of the applicant and Learned Counsel representing the respondents. अलग अलग order करोगे दोनों में. Top. So as to enable Learned Counsel appearing on behalf of the respondent to address this court on the point as to whether the impugned order has been passed by the learned single judge in violation of the Patna High Court rule. Yes, this High Court rules का वो कौन सा है?
Chapter 15, Rule 9.
Chapter 3, Rule 9.
Chapter 15, my
Chapter 15.
Rule 9.
इसको भी करना है. 8. That's along with this. Same date.
Keeping both
One-
together.
1 week.
8 and 9 both together.
1 week.
Hopeless minutes.
Item number 10.
Decision appeal to challenging the legality and propriety of the order dated 22/11/2013 passed by the Honorable Single Judge in petition 8757 of 2019. Milord, the writ petition has been filed seeking a direction from the respondent to pass the rejection order of 23/2/2019 passed by District Collector Noyagarh.
So where is the order? Where is the order of this court?
24.
Election.
1.
Not in the page, annexure 7, page 141.
Yes.
In the annexure 7, page 141.
No, you are challenging the order of the learned single judge.
Non-single judge order.
Huh?
In the page number 34, Your Honor, sorry.
Page number 34 is the writ petition. Or I am mistaken. 24 is the order.
Sorry. 24. 24.
What is wrong?
Lord, at the time of concluding the hearing on 23/11/2023, the Honorable Single Judge has verbally ordered that the writ petition is allowed and dispose the matter.
You can file a review, sorry.
And after that, on the time of written judgment, again this order has come. This is matter.
You could have filed a review. That cannot be gone into by us. And that is submission you could not have made before this court.
I am going to the main matter. I am going to main matter.
Main matter.
I am going, then that is the judiciary irregularities I want to mention. At the time of hearing.
Don't do it, Mr. Counsel. You are a young lawyer. You should not make this submission. And if you could have made this submission, but before the same London single judge, you could have filed a review. You could file anything. You cannot make this submission before the revision bench. This is one. The two, what is the illegality? There is no illegality.
Illegality, Your Honor, the petitioner has appointed as a Shiksha Sahayaka on 14/6/2007, and he has been disengaged by the district collector after 4 months. That is on 12/10/2007. And after that, he filed a writ petition in this honorable court. There is a writ petition 15026 of 2010. And at that time, the respondent, they have filed counter affidavit.
Don't forget, come to paragraph 22 of the judgment.
Connection failed.
Thank you. Yes. So what is wrong? So see paragraph 22, 23, 24, 2 and 23.
All these arguments of the respondent have been discarded by the previous writ petitions, and all these arguments have been already discarded by the previous writ petitions, and filed by the appellant on 2015, 2010, and the same logic has been discarded by this honorable court and ordered to the respondent to re-engage the appellant. But still, they as they did not do that, so they have filed this writ petition again in 2019.
Who filed?
Appellant filed.
You filed writ petition.
Last time I have filed writ petition in 2010. At that time, they have given a logic that at that time the respondent gave a logic that they have a resolution.
What happened in 2010 writ petition?
Writ petitioner allowed, and honorable court has ordered the respondent to reconsider the application and quash the rejection order of the district collector up to at that time.
No, but this is a fact. The what has been recorded in paragraph 22 is a fact. Petitioner submitted certificate issued by DI Schools Bhubaneswar. This should not have been taken into consideration. So how do you say that this finding is incorrect?
At that time, this there has been an inquiry by this honorable court, and at that time, all this matter had been taken into consideration in the writ 2010, and this is not one dispute at all at that time by the opposite party also.
No, but this is a fact. See, you were given 20 marks more, which was incorrectly given. That is the question. What is wrong in that?
Actually, I have engaged as I have 2 years experience as a MFE, and I have sufficient proof that
might have your claim may be correct, but you had not submitted. You had submitted a certificate issued by DI of schools, Bhubaneswar, and you could not have been given on the basis of that 20 marks.
20 mark, 8 mark. Actually, they have wrongly added 20 mark, but they rectified in their counter affidavit that 8 marks should be given. As there is there are 2 years experience, about 2 years, per year 4 marks.
So instead of 28 marks should have been given.
Instead of 28 marks should be given.
Where is that?
The Annexure 3107 order, the writ petition order of 2010.
And Shiksha Sahayak posts are there still.
Still, the Shiksha Sahayak post is not there.
Then what is the purpose of entertaining this?
Because at that time, there is illegality and the petitioner and the petitioner.
Legality and what?
And the petitioner had been suffering from last 17 years.
No, you are not suffering, you are unnecessarily resting. The petitioner in the present intra-court appeal has put to challenge an order of learned single judge of this court dated so and so, passed in WPC number so and so. Thereby, the petitioner's writ application has been dismissed. Stop. The controversy relates to the appellant's selection as Shiksha Sahayak, comma, taking block as a unit. Stop. The appellant had applied for this said post in the year 2006.
2006.
In the year 2006. Stop. Next. It appears from the impugned order passed by the learned single judge that in the process of selection, the appellant was awarded 20 marks more, taking into account the certificate, NFE certificate issued by the, what is DI of school? District Inspector. District Inspector. District Inspector of Schools, comma, Bhubaneswar. Stop. Learned counsel for the petitioner does not dispute that based on the said NFE certificate issued by the DI of schools, comma, the petitioner was not entitled to 20 marks.
He was entitled to 8 marks.
But was entitled to 8 marks based on his experience. Stop. Next. The next, be that as it, what was the total marks?
Total mark 98. After adding 8 marks, the total mark comes to 98 marks. And the cutoff mark was 94.
First off, he submits that if 20 marks was to be excluded, the petitioner, all right, and if 20 marks was added, then 110 out of 100.
If 20 mark will be excluded, then 90. But if 8 mark is again added, then 98 mark.
20, you get 110. You are getting 110?
Yes, 100. 100.
110 out of what? 100?
Out of 200.
Out of 200. Now we have understood.
But the cutoff mark was 98. And the after
the applicant would have been awarded 90.51%. Full stop. However, if 8 was added to the said percentage, the appellant would have scored 94.51%. 51%. Stop. In such circumstance, comma, keeping in mind the fact that the cutoff marks was 94.44%, comma, the appellant would have been selected for the post of Shiksha Sakhya. Shiksha Sahayak in 2006. Stop. Next, we are not inclined to interfere with the impugned order passed by the learned single judge, taking into account the fact that the learned single judge has meticulously dealt with the appellant's score and the cutoff score prescribed for the UR category candidates. First off, in the present writ appeal relating to a dispute regarding selection for appointment to the post of Shiksha Sahayak, which post has been abolished. Post has been abolished.
Now the petitioner, another applicant is praying for post of the, when the post is abolished, at that time.
All right.
Junior teacher.
Yes. Which no more survives. Sentence for. We are not inclined to interfere. That's a writ appeal.
This is illegality by that.
Maybe illegality, what can be done? Nothing can be done.
Now the post is.
Even if we accept your submission, nothing can be done now.
Can be other option given.
As your lordship know, in previous day, last day order Miller.
Another matters cannot be taken up.
56.
Now I have got the order of my lord's insurance order.
They move
Pointed out only 2 matters have to be differentiated. The rest has to be taken up for cover matters. So I am giving that order, my lord, I have given. And the list I have given only 3 items I have to separate it. Otherwise, everything will be covered by this. Yes, my lord.
What 9.6?
And 49.3, my lord, that is a separate matter. That is regarding admission to the nursing course matter. Different.
All right.
And my lord, then 46, 2 and 3. There is Salam that nursing higher certificate matter, we have already given him NOC. That is pending for disposal, final disposal, subject to the decision of the Assembly. This will take up another day. They have already filed the count. These 2 and that 3. Kala. Both images. Already he has been given the NOC, subject to my lord's decision. So that is the rest other certificate covered up.
Miller, in item number 50.
49.4 probably. Read petition number 18877 of 2014 minutes. Lordship's last order. That is covered by Lordship's last order. Yesterday's order.
That same order.
WPC number
The same covered matter.
All right.
Your Lordship. Item number 49.5, Your Lordship. 49 sub item 5. Psychology of physiotherapy. Your Lordship is covered under the same order.
My lord, this is.
Your Lordship, 49.5.
Yes, this is just only separation of this order is my lord.
Second last is physiotherapy.
My lord, this.
There are 3, 49.5, yes.
49.5 is my lord different. It's what that he has already submitted the hospital affiliation letter, or we will accept that and we will allow him to go for insurance.
No. In past in terms of that order. Which we
Yes,
passed
yes,
yesterday,
yes,
so some
yes,
changes
that
were
can.
there, that is why we are asking.
Yes, that can be.
Other order will cover.
Yes, ma'am.
But regarding that 49.5, you have to raise the law.
Yes.
Particular Nobel Prize.
Yes, ma'am.
Your Lordship.
Paragraph. From nursing course, it will be nursing course. And this won't be that instruction regarding 23/10/2024, that won't be there. So that paragraph will go.
Yes.
Paragraph 4.
49.3.
Paragraph.
No, that one. Yes, madam.
What?
Yes.
Yes, means
That
what?
I am submitted that the instruction letter.
That para should go.
Yes, that will go, my lord.
Nothing, yes.
This is the last date then.
Last week. That is already over, my lord.
So then that order will be different, it won't be covered by this order.
No, that admission is over, but we will allow that. There is no restriction from any.
In INC.
There is no last date.
Yes, ma'am.
Para 6 will also go.
49.3, my lord, that will be separated. 49.3, please.
Wait, 49.5.
Yes,
You have given this, it will be covered, it will not be covered. We are trying to find out which paragraphs we should not include. Paragraph 6 will not be there. If it's a past order, we don't want to pass an incorrect order.
Oh, yes, my lord.
In paragraph 7, have you made a request?
No,
So Indian Nursing Council.
no, that will not be covered with
Six,
that.
seven will be there.
Yes, no, my lord.
Only paragraph 5 will stay and then
9 also will not be covered.
sorry?
9 also will not be covered.
You will make available within how many days?
3 days, my lord, sir.
You will give. You will give within date within 1 week. Can you give?
Yes, yes.
One, two will remain, 3 won't be there.
Yes, ma'am. Yes, ma'am.
What were you saying about? Something else you were saying, I can. This,
49.3, my lord.
this you are saying some other day.
Yes, ma'am. And I have to file counter. And he should give a legible copy to me because I am not able to read the connections. He was there.
Global.
Satyanarayan. The lunch hour, he was there and he was telling me, I told him.
Passing order will come to- Okay.
Yes.
That will be only adjourned to some other day.
49.3.
He's there. Your Lordship.
My learner's is on his legs, Your Lordship.
Five, 11, 120. The asking council and then the council appearing with the take the council everything in like.
Let it be on 11. 11th matters are coming, let it be on 11.
11.
11th of November, Your Lordship. Your Lordship.
6 to 5 counter affidavit by 7.
Yes. But he will give me legible copy because I am not getting.
Please serve legible copy both of the day.
I'll, Your Lordship.
In order to file, undertakes to file the counter affidavit by 7/11/2024 after serving copy on the learned counsel for the petitioner, comma, If the learned counsel for the petitioner serves a copy of the eligible copy of the writ petition on him in course of the day.
Your lordship.
That-
There are 46 item, 2 and 3. That Kalam matter.
Yes. Next day or some other day.
Any other day, my lord, because we have already filed counter.
So pleadings are complete.
Yes.
Pleadings are complete as agreed by the party, counsel for the party. This is the case on 11/11.
Yes.
My lord, 11th, your lordship.
11/11. 11/11.
11/11.
Yes, yes.
Yeah, 11.
You are approving what we are saying.
Or you are saying not 11/11, but 11/11.
No, madam. I listen that 7/11, your lordship, perhaps I. 7/11, therefore I.
7/11 is the
11/11.
11/11.
Everything is over covered.
Our done.
Yes.
Miller, in item number 56, I filed a memo what I was praying for in the past after your lordship,
Take
Miller.
back the state.
Yes, Miller. That is Gayatri College. I have solved the copy of the memo to my respected senior Miller. No, Miller, with a lever to approach the appropriate authority one. That is DMET, Miller. Because my representation is also there, Miller. My representation is there. To that extent, your lordship may kindly please to pass the order. Liberty may be granted, Miller. There is sympathy, Miller, because yeah.
File some memo.
36.
Please add on.
That it is handwritten by my junior Miller. If your lordship permit me, I can read it out at your lordship convenience. Obliged.
Oh, yeah, also if you like, I can also read that.
Withdraw with a liberty to approach.
Must be filed by the counsel for the petitioner. For the application. With liberty to approach the authority under the state government.
Public DMET Odisha, Miller. DMET Odisha, I could not mention Miller. Since DMET Odisha, the authority itself.
Has filed a memo to withdraw the writ application. Mr. DP Das, learned counsel for the petitioner submits that the application will be permitted to be withdrawn, granting liberty to the petitioner to approach the DMHC for considering his grievance. It's grievance. The writ application is permitted to be withdrawn with the liberty as read for.
Obliged, Professor.
May I want to follow here, my boss.
Lord, as I am told, my lord, with my lord's kind permission. With my lord's kind permission, my lord, one item number 36, that is that court manager's matter, where Mr. Asukman came here appearing there. But I was talking to Mr.
In this case, may I pray, I have also taken consent. Next week, any day, my. Yes.
Week after.
Week after us. After 1 week, yes. Can be then.
That's it. So, court manager matter. My learned senior saying week after next week, subject to.
Any day they are ready. Instead of adjourning it piecemeal, my lord, from day to day, from your lordships and the beast and also I am vigilant. Any day they like.
After 1 week, my lord.
Approved by learned counsel for the party, this is the case on 12/11/2000.
Yes. Yes, my lord.
That one. 36.
That is Wednesday.
These cases on 12/11/2024 to be taken up at 6 p.m. For the common need.
Item number 12.
This is a service matter arising out of the order of the Honorable Single Judge.
No, it was heard at length, Mr.
It was heard at length, my lords. At page 13 of your lordship's brief, the digitized version, there are 5 broad points which we have raised. Just to give a recap of our points.
Yes.
Page 13, I'll just read out the headings. First is errors apparent on the face of the record regarding that presenting officer, your lordship may recollect. Then second point at page 2 of that note, that would be page number 14 of the digitized version. A violation of natural justice has to go back to that same stage in case there is a violation. Third is impugned order of the appellate authority not considered by the Honorable Single Judge at all. This is significant in the context of the earlier round where the matter was remitted back to the appellate authority. This we have also mentioned. At internal page 5 of that note, last portion, we have mentioned that since it was remitted back to the appellate authority, that order at least should have been taken into consideration. Page 6, if impugned order is allowed to stand, Rule 44 would be rewritten. That's our fourth point. And last point is ample opportunity was given before the original authority. This also has been reflected in the earlier round of litigation. These are our 5 broad. My friend would.
Have you filed your written notes?
I have filed my note.
Sorry.
I have given and I have dealt all the points in that. And
we have heard and senior counsel appearing on behalf of the petitioner. Why the matter was adjourned on the last date? Oh. What is it? The respondent has filed his written notes of argument. Does this matter for judgment? 8 weeks. Yes.
Item 11.
Interim order continue.
Interim order shall continue in the way.
Great.
At 11.
My lord, may I please, your lordship? The appellant being aggrieved to the order of Honorable Single Judge, dated 2/5/14 under Annexure 1 of this writ appeal, has filed this present appeal praying for setting aside of the same with other consequential reliefs. My lord, this appellant was before the Honorable Single Judge, challenging one order of opposite party number 3.
Where is the order?
My lord, the present input order is started from page 20, running up to page 25. That is the order of Honorable Single Judge, dated 5/24. My lord, the writ application has been dismissed on the ground that this petitioner has himself abandoned to join at Balipatna block. Therefore, the
No, this is WA number.
My lord, this is W1600.
Item number 11. Yes.
The Honorable Single Judge has dismissed the writ petition without going into the pleadings he made in the writ petition as well as counter and rejoinder. Only one ground has been taken for dismissal, that this petitioner has himself abandoned his job to join at Balipatna block. Because this is not a fact, this is not the ground taken by the opposite party in their counter. This is not their case. This is also not my case. But this ground has been taken under on the basis of this order of dismissal has been taken. Milord, this petitioner is a BSc graduate in agriculture. Having been selected pursuant to a procedure in the presence of a government officer opposite parties, his appointment was made as a block technology manager in Balipatna block in the year 2012. And pursuant to that, he was also provided training. Thereafter, he was made to continue in such post. And in the year 2015, what arose, one officer of the block technology team, he made telephone to his wife in his absence, and that was opposed by his wife, and one FIR was lodged. And according,
who are you?
I am the petitioner.
Petitioner working as what?
Petitioner was working as block technology manager.
Under what?
Under the one project of a government that is known as ATMA, Agriculture Technology Management Agency, that is operating in every district, every block under the state government of agriculture department. He is a BSc graduate. Pursuant to selection made by the government authorities, his appointment was made in the year 2012.
Who is the learned single judge says that you are working under service provider?
No, yes, that is a fact. Those persons who are working under the project, they are appointed by the service provider working on the state government project pursuant to selection made by the state government.
Sir, where is your appointment letter?
Your Lordship, might see Annexure 1.
Where is your appointment letter?
Annexure 4. Your Lordship may kindly turn to Annexure 4 at page 43 of the writ petition. That is now Your Lordship. That is 43 of the writ. Yes, my Lord. Annexure 3, my Lord. With reference numbers 359 dated 22.
This is your appointment letter.
This is, my Lord, this is the appointment letter issued by the Bhumisri Agro Private Limited. Bhumisri Agro Private Limited. By this NGO, he is inducted into service to work in ATMA. ATMA is a government project operating under the state government.
Mr. Atma may be taking services of a shop.
Yes.
So therefore, every employee in the shop becomes employee of Atma.
No, that is not the fact here.
That is not the fact. What is the fact? Let us see your appointment letter. Everything will depend on that.
Milord, you're also going to see this is the order of appointment issued, and pursuant to this, his engagement was made. This is at page 16, Milord.
Where is your engagement letter?
Milord, there is no other engagement letter.
No other engagement letter, then you don't have any case.
Milord, these are the Honorable Single Judge, what has happened, pursuant to the direction of this Honorable Court, under Annexure 313.
Sir, we cannot decide cases in here. There must be some substance. What are you? You are not disclosing your identity, and you are asking us to adjudicate.
Milord, this petitioner is working as a block technology manager.
Block technology manager in United States or in India?
Milord, that is in Khordha district in Balipatna
in
block.
In Khordha district under whom?
Under the agriculture department.
Under agriculture department, where is the engagement?
Milord, engagement order is at Annexure 4.
There is no engagement order.
That is, your Lordship can see, Milord, I mean, permitted. Milord, that is the disengagement order. That order shows that I was appointed through the Bhumisri from the year 2012 and service provider. That is what has happened. Thereafter, order of disengagement, the order of engagement was passed thereafter, but I was not provided place of posting. I was made to run.
Mr. Counsel, do you have your engagement letter?
Milord, your lordship may kindly grant some time. I want to.
No, sorry.
Your lordship may can see the very ground on which I have approached your lordship in the present appeal is that the ground on which the writ application is dismissed, that is not the ground in the counter of the opposite party. That is also not my case in the writ application.
Please appreciate this, that even without counter affidavit, your writ petition could have been dismissed. There was your writ petition is not required to be decided on the basis of counter affidavit. Your claim is to be decided on the basis of your pleadings in the writ petition.
Milord, my submission before lordship is that pursuant to one order of this honorable court, my case having been considered, the impugned order was passed under annexure 20.
We have heard you, Mr. Counsel. The petitioner and the appellant in the present writ appeal has assailed an order dated. There's an order dated. Just
2524.
Order dated 2/5/2024, passed in WPC number 1318360 of 2020, whereby the petitioner's writ application challenging an order dated 8/3/2020, passed by the project director Atma, Khurda, has been dismissed. So, from the impugned order, it appears that the petitioner was working under a service provider, providing its services to Atma. Stop. Despite repeated queries made by this court, the petitioner has not been able, the appellant counsel for the appellant has not been able to show the petitioner's, the appellant's engagement letter so as to establish that it was engaged by Atma, which according to him, is stayed within the meaning of Article 12 of the Constitution. Stop. The appellant was apparently engaged by an NGO. According to the petitioner's case, appellant's case, the appellant was engaged by an NGO, which is not a state within the meaning of Article 12. Stop. In such view of the matter, no interference is required with the impugned order passed by the learned single judge in the present court appeal. This appeal has absolutely no merit and is accordingly dismissed. Yes.
Lord, with due permission, I want to draw your attention. So the maintainability of the petition is concerned, that is already decided by the Honorable Appeals Court. That has been taken note of by the Honorable Single Judge while passing direction to the state government to consider his case and pass necessary order. Because that aspect was gone into at the time of passing necessary order. And pursuant to that, the impugned order was passed. Direction was made to the OP number 2 to consider his representation and pass necessary order. But the impugned order was passed by the OP number 3, who is not the authority. He is himself saying in the impugned order that I am not the authority to pass the order. However, at the instance of a higher authority, I am passing this order. That order was under challenge. Notice was issued. Case was kept pending for 4 years. Counter order were filed. But at the time of final adjudication, the case was dismissed on the ground which is not the ground of opposite party writ petition. Maintainability aspect is already taken note of. I have also reflected that order at page 12 and at page 9 of the writ petition. That is also, that
Were re-engaged at
Yes,
basis
ma'am.
of the orders of the Honorable Minister.
Honorable Minister said that this
No,
person
that
should.
I just saw that.
Miller,
order.
Annexure 6, 7, 8. I want to take a lordship to Annexure 6, 7, 8. What has happened after my disengagement? Again, my case was sought to be considered by the authority, and under Annexure 6C. Under Annexure 6C, a letter was made, a move was made by the OP number 7 or by the OP number 2 to the OP number 6. OP number 6 is the real appointing authority that order of engagement be passed. That is the contents
Mr.
of
Swai.
Annexure 6C.
Is it not a fact that you were engaged by the service provider Bhumi Shri Agro?
Yes, Milo, that is a fact. There is no dispute over that, Milo.
So that
I
is all.
cannot dispute that.
That is all.
Milo, my submission that though offer or
There's no engagement letter in the engagement letter pointing the petitioner is applicant is available. That's why we are not inclined to entertain any submission advanced on behalf of the applicant.
Item 13.
Yes.
Ships kindly take this matter taken up at next date. My senior is not here.
I think last date also same prayer.
No, he was here.
He was here.
He was
here
in
before
other.
launch. He is
He
also
is in other court. He is coming. He is on his way. He is in other court.
He's on his way. From where?
From CGM.
So who is
Password.
can he avoid Chief Justice's court to attend the court of the Chief Judicial Magistrate?
No, your lordship. Kindly password.
That cannot be a ground, madam.
Please tell us what the case is. By the time he'll arrive.
All right, tomorrow.
Tomorrow you read and come. If he's not there, you place the case. All right.
Lordship may not kept it tomorrow. Anyway, next time.
No, as requested on behalf of the
Oh, pleasure.
Item 14.
Madam, what is your name?
B Puja.
B?
B Puja.
P or B?
B.
B for Bombay?
Yeah.
All right. We'll hear you next week. Madam,
14.
Wait, please, your lordship. But here the order of the honorable single judge in the subject matter challenge. Page 19 is the impugned order. Here we have the auction purchaser. The writ petitioner was an auction purchaser in a sales tax proceeding, where actually it was put to auction by the debt recovery tribunal, that OPDR Act, under the OPDR Act. But that was the subject matter of challenge before the ADM. ADM set aside the same, and the revisional court confirmed that was challenge in writ application. The honorable writ application in the order, it was passed that you can file a suit as per the OPDR Act, section 36. Challenge and you establish your title because I am the purchaser prior to the auction sale. Petitioner is the appellant, is the purchaser prior to the sale. In the suit, he was also a party. In the suit, it has been adjudicated that the sale executed by the OPDR Act is absolutely void, illegal, inappropriate in the eye of law. And interestingly, the day the order was passed by the ADM, Additional District Magistrate, cancelling the sale, he had already taken refund of the money. The sale proceeds he deposited, he has taken refund also. That the civil court has also taken note of. Judgment has been delivered. He has not challenged the judgment. The appellate authority for recovery of their amount had challenged. Interestingly, the sale that was made in my favor, that was a portion of it was apportioned so far as the amount is concerned, the dues of the original owner, who was a mining operator. Secondly, after the death of the mining operation, the this proceeding under the OPDR Act, the legal person not made party, no notice was issued. Because otherwise, Section 6 would have been a bar for sale. Section 6 of the OPDR doesn't stand as a bar. That has been held by the civil court also. So he doesn't have a locus to challenge the correction of the record in my name from the original recorded owner. He is also not a recorded owner. The Honorable Court thought that the matter relating to the auction sale is the subject matter of challenge. Therefore, he should be a party in the mutation proceeding, like correction of record proceeding. But that is subject to result. So it has already been corrected in my name. The decree is in my favor, and he didn't challenge the decree. Therefore, he doesn't have a right. That was brought to the notice of the Honorable Single Judge.
So he is the party in the suit.
Yes, because the party contested, lost. He didn't challenge an appeal. And he had, prior to that, he had taken return of the money he has deposited.
Correction of records, was he a party in that petition?
Yes.
Says he was not. See paragraph 6 of the.
No, in the correction of record, he was not a party because the recorded owner, he was not a recorded owner. A recorded owner were my vendors.
Having bought that in auction, was it not necessary that he be heard?
But he has already lost. The auction sale has been held to be bad by the ADM. Commissioner reversed that was challenging the REIT. REIT got directed file a suit. I filed a suit. He contested the suit and lost. I have filed all the records. It was there in the REIT petition also. So let's we kindly have a look at the REIT petition, Annexure 3. Annexure 2 is the judgment, page 11 in the REIT petition.
So the Learned Single Judge has remanded the matter to be heard in presence of that opposite party.
Yes, but that is already over.
Over, that is why that has been set aside.
That's why I am before your lordship.
Yes.
I am before your lordship because of that reason. Because he is not a party, required to be a party because he has lost. He has taken return of the money. The money he deposited for the auction sale, he has taken return.
This has been listed for the first time.
Yes.
First time, Malak.
It should not.
In the date chart, I have also mentioned detail.
It's for notice. Who received the notice or state?
Sir, opposite party number 1, Tapan Kumar Pandit.
Opposite party number 1. You will receive notice for the other.
I'll receive for 2 and 3. 2, 3, 4.
2, 3, 4.
Who are these 5, 6, 7, 8 pro forma respondents?
Pro forma.
So you don't have to take notice on them.
The stay operation of the
will
order.
accept notice 2, 3, 4.
We make it clear that any decision by the additional commissioner, consolidation pursuant to this court's order dated 6/8/2024 shall be subject to final decision of the present appeal. Final decision in the present appeal. Yes. 1 week.
Item 15.
My lord, in this case, I have challenged the order passed by the Honorable Single Judge.
Item 15,
The
Your Lordship have
Annexure.
filed a cross appeal in this matter, and the state has also filed a connected writ appeal in the matter. Both have not come up, Your Lordship. Number hela 2562 of 24. State ro hela 1943 of 24. 2562 of 24, Your Lordship.
It is stated at the bar that the order which is under challenge in the present appeal is also under challenge WA number
2562, Your Lordship.
2562 of 2024 and
Your Lordship, 1943 has been filed by the state in a connected
194?
matter. 1943 of 24.
3.
1943. In a connected matter, they have filed.
43 of
24.
list this appeal along with WA number so and so on. Next week.
Yes, ma'am. May I pray, my lords, let them serve me a copy of those things so that I can
apprise my lords about the correctness. Those copies they say.
I can give
Correctness
for
is
my
here.
lordship, the state writ appeal copy, I don't have my writ appeal copy, I will.
State is to file me one copy.
You also serve a copy of your appeal memo.
He has already got my copy.
This is my appeal copy.
Oh, yes, my lord. There's no difficulty, I can give it.
That without
There's no
order.
problem, no problem.
Item 16.
Please, lordship.
You have entered appearance in this case.
May I please, your lordship? The petitioner challenges the judgment at 25/6/2024 passed by the Honorable Single Judge, my lord. Informed order is at Annexure 1. My lord. Starting from page 21, my lord. The operating part is at, my lord. From page number 28, my lord. The operating part is at, my lord, page 29. Para 9, my lord. The decision to grant financial assistance instead of an appointment is consistent with the guidelines established by the corporation. The corporation practice of providing financial assistance of rupees 1,50,000 to the next of the kin of the deceased employee in lieu of a job will continue unless the board of directors with government approval decides otherwise. Therefore, my lord, in para 10 and 11, there are two judgments are cited by the Honorable Single Judge regarding applicability of the rules, my lord. The facts of the writ application is that, my lord, the father of the petitioner, while working as accountant assistant, died on 23/8/2018, my lord. My lord, thereafter, the petitioner submitted his application for appointment under rehabilitation assistance scheme on 25/2019, my lord. When no action has been taken, the petitioner submitted a representation before the authority, and they have also not taken of that, considered that representation. Thereafter, the petitioner filed a writ petition bearing 16066 of 2019, my lord, in which this honorable court has directed to consider his representation. They have considered and rejected the same on the ground that and directed the petitioner to receive 1,50,000 towards RAS for self-same employment in lieu of employment in OLIC on 25/11/2019. Challenging this order, the present petitioner has filed the present writ application. My lord, when the writ application was pending, they have given appointment to one Nirod Kumar Satpathy under the RS scheme, my lord, despite refusal made by the Honorable Apex Court, my lord. My lord, that order is at.
Refusal means Apex Court passed an order not to appoint
Not to appoint him, but he is entitled to get the financial assistance. My lord, page 1010, my lord. In SLP's number, civil appeal number 9627 of 2016, operating part is at, my lord, 112. Running page 112, my lord. So, furthermore, when the court desires.
But Annexure 5 is your affidavit.
Yes, ma'am.
Affidavit with annexure.
Yeah, affidavit with annexure filed by the, my lord, opposite parties, my lord. Respond number 224. They have given.
Yes, yes.
May I place, my lord? Page
Yes.
112. My lord, for when the court desires to see the information obtained furnished under the RTI Act with regard to the 7 post, Lord and Counsel for the respondent was unable to place the same. In the above circumstance, we find that the Honorable High Court was not justified in taking cognizance of the contempt proceeding and in passing the impugned order. We therefore set aside the same and allow this appeal. This will not affect the entitlement of the respondent.
Where are you reading?
My lord?
Where are you reading? Which page?
My lord, 112, my lord. To the read of it.
Order starts at 110.
My lord.
Order starts at 110.
My lord.
You are relying on this.
My lord, I am not relying, but this is the discriminatory attitude adopted by the respondent. This fact has not been taken into consideration by the Honorable Single Judge, my lord. They have given appointment.
If what you submitted, what we understand, they appointed that person on because of fear of contempt.
No, my lord.
Yes.
No fear of contempt, my lord. My lord, this order clearly shows that the Honorable Apex Court has dealt with, my lord, fifth line.
See, Mr., you have been held to be entitled for financial assistance.
My lord, when there are two schemes, earlier they have adopted the scheme to give an appointment. In the year 2009, they have adopted a scheme, Orissa Lift Irrigation Corporation, to extend 1.5 lakhs in lieu of appointment under our scheme, my lord. During, my lord, in force, when that scheme is in force, they have given appointment to one Nirod Kumar Sarpati during pendency of my writ petition.
Maybe.
My lord.
So
Despite
you are saying that we should follow some illegal acts done by them.
Illegal hands, my lord, they have also taken that negative equality. But my respectful submission before your lordship is that when the Honorable Apex Court has refused to give appointment to that person, they have extended their benefits. It cannot be a bona fide mistake, my lord.
So we should follow
My
the
lord,
Supreme Court
thereafter-
decision or their action.
My lord, thereafter, my lord, pursuant to another person, they have given appointment in the year 2022, pursuant to the decision of Division Bench of the Honorable Court in writ appeal number. My
No,
lord,
Mr., please don't cite others' examples.
my lord.
Has this court directed the appointment?
Yes, my lord.
So why are you relying on what they have done instead of saying whether case is covered or not?
My lord. My lord, that is 168 page. My lord, Justice Ratho is also party to their judgment in writ appeal, my lord.
Yes, where is that?
Where is
My
it?
lord, 168, page number 168. My lord, starts from 165. Second para, we cannot understand the worth of such a stand because as per their own admission, OLEC has given appointment in 2020 to one of the legal heirs of a deceased who died in harness. Therefore, we find that the stand taken by the Odisha Lift Irrigation Corporation Limited is discriminatory.
Oh, but now the referring to
Order passed in writ appeal 199 of 2018.
your page number?
Page number 165. Running page 165, start. (27 for 2021).
Why are you referring to that? Then in that case, the limitation was not condoned.
Limitation, but therefore the limitation has not been condoned and direction was issued to give appointment to that appellant. Respondent, my lord.
See, for granting you relief, we will have to set aside the decision of OLIC. Can we do that?
My lord.
we will have to set aside the policy decision of the Lift Irrigation Corporation.
But I am claiming, my lord, this is the discrimination
Parity.
has been given. They have one hand, they have stating that we are formulated a scheme to provide financial assistance scheme. When the scheme was in force, they have given appointment under the RS scheme, my lord. And posts are vacant, my lord. But the Honorable Single Judge has
So
told
have you
that,
challenged their appointment?
my lord,
Have you challenged their appointment?
no, my, during pendency of the writ petition, they have given appointment, my lord.
In that case, appointment had been granted, that was cancelled. The writ appeal you are referring to, their appointment had been done, that was subsequently
Therefore,
cancelled.
referring to that Nirod Kumar Satpathi's case, my lord's direction was given. Dismissing the issue. My lord, posts are also vacant. The another point was the petitioner cannot claim as a matter.
They are saying that because of financial crunch, they are unable to appoint.
But
That was the decision.
there was, my lord, posts are vacant and they have recently appointed some
All right.
person and one post is vacant, my lord. That is at page number.
An order dated 26/5/2024, 25/6/2024, passed in WPC number 27929 of 2019, is under challenge in the present intra-court appeal, whereby the petitioner's writ application seeking quashing of later dated 25/11/2019, rejecting the appellant's claim, the petitioner is no appellant's claim for granting appointment on compassionate ground was rejected. It is apparent from the impugned order passed by the learned single judge, which is not in dispute, that the respondent Odisha Lift Irrigation Corporation had decided in June, decided in its meeting held on 21/6/2013 to provide financial assistance of is 1,50,000 to the family members of each of the deceased employees of the corporation. Stop. The appellant's father died on August 23, 2018, much after coming into force of the said policy. Stop. Next. When counsel appearing on behalf of the appellant has submitted, without disputing the existence of the said policy of the OLIC dated 23/8/2023, that despite the said policy, the OLIC has given appointments on personal ground consequent upon the death of its employees. Stop. He has submitted that denial of such benefit to the petitioner is discriminatory. Stop. Next, we are not convinced with the said submission advanced on behalf of the petitioner, appellant. Stop. The petitioner cannot claim parity on the ground that some of the employees were granted compassionate appointment contrary to the policy of the OLIC to provide compensation in lieu of compassionate appointment. So stop. it is noteworthy that the said policy of the OLIC was not challenged, was not under challenge. Stop. In such view of the matter, we do not find any illegality in the impugned order passed by the learned single judge requiring our interference. Stop. This appeal is accordingly dismissed. Yes.
Item 17.
Item 17, there is an endorsement on the cost title that I have not filed the amended cost title, that I filed it today, my lord. And your lordship may see the order dated 7/10/2024.
May I pray, my lord, so much I am appeared in this case. But no, the appeal has not been solved on me. My lord may be directed, my lord.
You want us to see what?
Para 3, my lord.
Para 3 of what?
Of the order dated 7/10/2024. Order number 2, my lord. Your lordship's order. Should I read out my?
Yes.
This,
That was required to be done by the
this-
registry. The registry will correct. Yes. Both of registry को करना है. They cannot. Huh? So you do it.
I've done it. I
You
filed
have
the,
done it.
I have
All right.
filed the amended cost title.
Let a copy of the,
There.
Yes, he filed today, my lord.
let a copy of the writ appeal be served on counsel for
Counsel for the
Respondent 1.
respondent number 1,
respondent number 1, Mr.
Anjan Kumar Chandra.
who has entered appearance through Wakalatnama. You have filed your
Yes,
Wakalatama?
yes, my lord, I have filed Wakalat.
Through Wakalatama.
Also,
This matter on 2 weeks.
My-
2 weeks.
Meanwhile, state may be directed, the other part of the,
serve a copy on the state because they were.
I have already served on that day. If you are
Okay.
request-
Because here, just to assist the court, the Secretary Revenue and Disaster Management Department had been implemented as a party to assist us as respect as SCBC.
My lord, as a respondent or appellant?
Respondent,
but-
respondent.
It is indicated as appellant, so that is why.
Where?
Eh?
In the
Note sheet of the cost title.
Lordship may kindly see the office note.
Office note.
Yes, ma'am. State
The
of
cost
Orissa,
list, in the cost list it is written.
Yeah, that's it.
cause list.
No, we had in fact, that was for purpose.
Assistant.
Ah.
So, if,
Oh, so they do. Wrongly. Tick.
I have implemented as respondent 3.
All right, that is not.
In the original writ which I have filed, in the original writ application which I have filed as a petitioner, I have not been implemented as a state as a party.
you know that,
Only-
you know that, that
my
way that order was passed so that they will assist. But. Page 16. Yes, sir.
Okay, will that be corrected? Oh, that's,
Correct, correct.
no, he is going to file.
No, but this also. should be corrected.
Now, once that is one he filed, this concept, and that will be removed the other. Huh? There is a, it appears that that apparently out of inadvertence, the registry has incorporated the name of
State of Odisha.
Huh?
State of Odisha through Secretary Revenue and Disaster Management Department as applicant number 3 in place of respondent number. What will be the serial number of the?
3, my lord.
See, respondent number 3.
Yes, my lord.
respond number 3. Let necessary corrections be carried out.
You have already filed one consolidated first?
Yes, my lord, I filed.
Mr.
He filed.
Also states that he has already filed a correct consolidated cost title of the
He filed today.
He filed today.
Today.
E filed karna. From the next week, we are going to introduce a system that once a writ application is filed, that will be or such pleadings where the state is party, that will be automatically transmitted to the Advocate General's office. So no requirement of acknowledgement of that process that takes 2-3 days time.
So now
So-
this has to be an alert to provide you with the copy.
So no defects shall be generated of non-service of the writ petition or any pleading on the estate. So that defect will not be there.
It will not be that
It
your
will be
plea that I
directly
have not received a copy, that also may not be considered. So that you have to be aware.
From the next week, next week I
2 weeks, my lord,
will
I will be directed to survey a copy of the writ application.
that will-
I'll
Yes.
So you evolve some system that you can access that.
That requires manpower.
Not
Yes.
manpower, if you can do it also.
No, you are doing it.
Yes.
Already you are receiving e-briefs
Yes.
and you are taking out the getting the printouts. After 1 week, but see, they have to show acknowledgement.
No, so that has been done away. So they have to be prompt in getting the copy.
Yes.
So they have to check the list and provide you the copy.
Yes.
Item
Because
number
it
8.
has been reported that 70% of the defects are because of this
non-service of.
non-service of copy on the estate.
So that's
So that defect will not be reported even.
defect will not be reported and that CNR marking will not be taken cognizance of, which they usually give to you CNR. Can't find the time. They will say CNR copy.
Item number 18.
Next week, when you will come?
12.
Number of cases.
May I please? In this case, the order under Annexure 8.
Annexure?
8 is 36 of the Honorable Single Judge is the subject matter of challenge. It's a very small issue involved in this case, my lord. The present appellant and the respondent number 4 joined in this particular institution in one date. They have also joined in the same date. They have also been approved and paid their salary under the block grant scheme of the government from a particular same date. But the appellant is senior to the respondent 4 on 8th date of birth. I am senior. So as per the settled principle, my lord, the seniority is to be fixed since everything is same. The date of birth is the criteria. So I was to be declared senior. In
So
fact,
how were you appointed?
appointed by the concerned governing body, because this is a private institution at the relevant time. Thereafter, government has given some aid.
So they must have conducted some process of selection.
Yes, they're on different departments, not from the same department. They're not from the same selection. That's
Okay.
probably because I am a lecturer in history and the other person, that's not 4 is for the economics. There are different selection. Had it been one selection, my lord, the merit list as my lord's mind, it is the merit list. But here there is not the fact. So now, my lord, in these private institutions, when it was not aided, the government had introduced a circular for appointment of the principal, because in fact there is no post of principal. They have to be appointed from among the existing staff on the basis of seniority. Even after became added, they have issued the same principle saying that the senior most approved teaching post will be the principal in charge. And there is a rule, my lord, the recruitment rule, which also states that the post of principal, there is a reader is equivalent to the post of principal.
No, but the yes, learned single just says.
Yes.
Come to para 7.
That I am just clarifying. These are the facts, my lord.
Yes.
What happened? Just two documents, my lord.
In fact, one Jyotirmay Nanda was the senior most. She was the principal since 2013. Annexure 6, page 34. After her retirement, I became other existing staffs. I am the senior most. Therefore, the government in Annexure 7, page 35, may kindly reclaim. On 10/11/22.
If this matter was heard.
No, in the last week it was there. I was just telling the facts. My learned friend in the other side, they took time.
Yes,
That is-
because I vividly remember this.
Yes, that is just last week it was there, but
Yes.
in fresh in mind. So in Annexure 7, I was approved as the principal in charge after the retirement of the person who has retired. So this order, my approval as the principal in charge of that particular institution was challenged by this respondent 4 in the writ petition. In the writ petition, these facts were undisputed. That is also quoted. But the Honorable Single Judge, by referring to his one of the earlier judgment of this Honorable Bench, directed that a person belongs to the outside another institution to take over the charge of the principal of this institution in addition to his own duty.
That matter was taken up. I remember that.
That was a different matter, not this.
I have also stated the same facts. Maybe in the other matter, somebody might have been arguing this case. So my response submission is, in that Premolata Raut case, which has been referred to by the Honorable Single Judge, I not can have a glance to that judgment, what the Honorable Single Judge has held.
So was there any writ appeal file against that? Premlata?
As I have been told, the state has filed it. But I do not.
Rautra was there in that matter.
In a similar nature of matter, that is Ashok Kumar Mishra versus State of Odisha. That is WA 554 of 2024. Your Lordship have passed this order since no common cadre has been constituted.
I remember.
Yes, this is the order.
Mr. Rautra was one of the council.
Common cadre
This is the same thing.
No, but it was not
See,
one-
Mr. Shadad, I was under wrong impression that I have a very poor memory. I remember this.
Lordship disposed of that writ appeal that until the common cadre.
Yes, the single law. In that Premolata Raut case, the Honorable Single Judge has directed so that you directed the government to constitute the common cadre, and till then the existing ad hoc principle decided by the state is to follow.
Yes, we will follow this order.
So
We can
that
follow.
if this
Have you
order,
seen this?
I have not seen this. I'm just passing. My lord, I have
See
seen
it.
it. Yes, my lord. I am.
What is that number? Sorry.
Yes, ma'am. This common cadre, that is the only one part of the direction. I have no quarrel over this order, my lord. But what? Why you want to say, my lord? And have a glance to that Premolata Raut case, what is referred to by the Honorable Single Judge. That has been endorsed by in this particular case. In the Premolata Raut case, what is the direction? Well, the same direction. What my lord have held. Can you see, my lord? Para 7, the ordering question. Para 7, page 13, last but one page. Having heard and counsel for the parties. Shall I read, my lord? Having heard and counsel for the parties and taking into account the provisions contained under section 10C of the Odisha Education Act vis-a-vis Rule 8.3 of the 1974 rules, as well as the decision cited supra, this court, while disposing the writ petition, directs the opposite party number 1 to take immediate step for constitution of the common cadre as provided under section 10C of the Act, read with Rule 8.3 of the rule within a period of 4 months from the date of receipt of this order. This is what my lord have said now, 2 months. This is same. But next paragraph, kindly. Till constitution of the such a common cadre, the interim arrangement made by the state with regard to appointment of the principal in charge in different aided colleges in terms of the proviso to Rule 8.3 of the 74 rules shall continue. So now the state has already approved my appointment. That is my bone of contention here. In Annexure 7, the state has approved my appointment because I am the senior most in the existing institution. Till that common cadre is formulated by the state, I am to continue mine. But the Honorable Single Judge here has directed an outsider who is also waiting for a common cadre posting. Now an outsider, well, transfer is only permissible within the cadre unless the cadre is fixed or the common cadre is fixed. Outsider cannot come to my institution, or I can go to any other institution.
So what is the
So
cadre
that is
according
that
to
is why what the ad hoc principle, what it is stated in Pramod Rao case, is in Annexure 7.
No, what is cadre?
Well, cadre is a cluster of persons in the
Cadre is strength of service, as
Yes,
simple as that.
yes, madam.
All right.
So
according to you, you belong to which cadre?
I'm now the difficulty in this Orissa Education Act, I have to clarify. The normal sense cadre is
Therefore,
Yes.
therefore, if someone is brought from some other institution to your institution who is undisputedly senior to you.
No, he is not a senior person. What it is directed that you bring somebody, because the two person in the same institution are disputing together. So let a third person be appointed, and the third person is not coming on
All that
transfer.
we can clarify.
Third
that
person
the
is coming.
Third person who is brought.
He is coming in,
senior.
he is working in his own office. He is not dual charge. He is holding dual charge. His own office as well as this institution. That is the difficulty.
And he cannot be given dual charge, Mr.
That is the
Seek instructions.
This is the order, madam. I have got that order. Now they have posted somebody. Today morning has given me. Kindly see, madam. Just I'm reading out.
Let them do. Let them say. Because dual we cannot permit.
That they
One
have done
person
it.
cannot be.
A
full of
particular
knowledge.
institution. This is the department has passed this order in this case. This case. What they have stated, my lord. Shri so and so is directed to continue along with his delegation funds for addition to his own duties.
No.
That is the point, my lord.
That is not permissible.
When the government has approved me, let me continue.
Seek instructions.
I'll see it.
Let's this matter on. Within first 5 cases, so as to enable learned AGA to seek instructions as to whether person who is sought to be appointed as principal in charge of the college pursuant to the court's direction is already holding post of principal of any college or not, and his appointment is in addition to the charge which he is presently holding. Let us see.
My lord. Next week. That I have got the document. I can file it in
First 5 cases.
next week.
Item 19.
May I please, Your Lordship? My lord, the Honorable Single Judge order starts with 36. The dispute here, Your Lordship, is there are two.
Just a minute. Page 30, annexure?
Annexure, Your Lordship,
8.
9.
Annexure 8, 2505.
My lord?
Just a minute, sorry.
16,900.
Yes.
The dispute here, Your Lordship, is that there are two Anganwadi centers, also ECE center, my lord. Village Ektali, another is Mangad. The advertisement service area declared and advertised was for Ektali. I was selected from that place, and that is the finding of the this case has a checkered career, Your Lordship. Earlier selection was made on my behalf. It was challenged before the learned ADM. That order came to be challenged before Your Lordship in Honorable Single Judge. That matter again remanded back. Now these orders are reversed. That opposite party is the respondent is the eligible to be appointed there, because it are not two separate, though these are two separate Anganwadi centers, EC centers, but there are two padas, Your Lordship, of one village. But my humble submission of Your Lordship is the concept is the service area. It is not that it might be having, this ward might be having two, if it is having two Anganwadi centers, Your Lordship, is to be seen to which Anganwadi center I belong and to which Anganwadi center C belongs. My case before Lordship is, and as it was before the Honorable Single Judges, that I belong to Ektali and this post was advertised for Ektali service area. But though that, my lord,
Yes,
though your lordship, the learned honorable single judge has relied on that circular also, ECC circular and all that, yet it has held, my lord, the straight away, let me take your lordship to the operating parts, page 44. Thus, the crux of the matter is whether the opposite part number 5 can be treated as an ECU worker of Ektali revenue village. There appears to be no controversy in this regard, in as much as the letter dated 17/3/2018, the Tahsildar Josipur has categorically stated that Mangad is a Sahi or hamlet of Ektali revenue village. Such being the undisputed fact, it cannot be held that opposite part number 5 was not eligible to apply for engagement as Anganwadi worker of Ektali Anganwadi Center. And accordingly, the impute order reveals the ADDM is referred to the relevant guidelines and rightly held. Selection committee committed gross illegality and irregularity in not granting extra weightage of 5 marks to the OP number 5 while conducting selection of Anganwadi worker of Ektali Anganwadi centers, thereby depriving her from her rightful claim. As such, the selection was set aside and fresh selection was directed to be conducted by giving extra weightage of 5 marks. As against this order, your lordship, I have come before my lords. Now, in this connection, I will take your lordship first to the advertisement. Page 16, my lord, annexure 1.
Clause 3.
Madam,
Clause 3.
clause, so the paragraph 2 is Ektali, for which they are inviting application. Now, my lord, may go to rightly, my lord, clause 3. Prathini Anganwadi Kendra Nimanta Avodon Koribe, Sehi Kendra Seba Ancholo, service area Stai Basinda Hoitive. She should belong to that service area. With this background in hand, I made an application, I was selected. Now, your lordship, in order to substantiate my argument that I belong to the service area, your lordship may kindly look at the relevant, the concern voter list that I have submitted for both for Ektali and so also for Mangad, my lord, the other village. There are 2 different words. Page 51, your lordship, my serial is 304. And this is regarding Ektali village, ward number 1. These are in Orias, but my lord Justice Rathakan.
If you read out, anybody can understand Ancholika.
I am taking your lordship to that page, that's why I'm saying. Ward number 1, it is for ward number 1 at page 48, and my serial is at page 51, 304 and 306.
Just a minute, is it legible?
I think your lordship, mine is legible.
Again, read appeal page.
51, your lordship.
Just. 61. Page 58.
51.
51.
58 is another.
Next 10.
Next 10.
Yes, legible. Well,
Serial 304.
4.
Yes. This concerns your lordship is 48, ward number 1, Ektali, Gram Panchayat Ektali, Gramo Ektali.
What is that?
That is at page 48.
On top.
Yes, your lordship.
Gram Panchayat is Ektali.
Ta tola hala Gramo Ektali.
Put it.
Ta tola ta Gramo Panchayat tola
Page
Gramo.
51.
48.
48.
My lords, find it.
That is the starting of that.
It starts at page 47, 46. I'm taking your lordship to third
file
page.
your English translation.
My lord,
English translation of
Relevant
the-
portion.
relevant portion.
Relevant portion.
I was
You're
also
supposed to read.
asking him.
the English translation of Odia document, of the documents in Odia language. By what time?
By tomorrow, I pray for next week, my lord, Monday.
Tomorrow, let's just matter on Monday. Yes.
One moment. What is that? Gramo Ektali bracket Anganwadi.
Angana.
Angana means area.
Here, I will file that, your lordship.
Give the translation of ang also.
And account.
Yes, next.
Item 20.
Monday, my lord.
Used.
Tuesday.
Well, I am submitting the
No, it's 20.
full copy of the order sheet. Tuesday. Yesterday, this matter was there, my lord.
Yesterday it was listed, my lord.
20.
20, my.
Regarding that allotment of shop, full instruction was not there.
Full instruction. Today I have collected the full instruction.
So you waiting for a shop since 10 years? or
No,
what?
that is predicament.
Oh,
Lord,
predicament.
if they are granting
Page three, my
another
lord.
shop room,
Last page, my lord. I'm
they are
sorry, my
stating
lord.
that they are granting in
Page
some
3, my
other
lord.
place.
Page 3, last part.
One page was missing. But
Yes, yes.
Above all, the multi-utility center building is urgently needed for storing 5-truck load worth medical stock, drugs and saline about to be vacated out of the old indoor building that has been declared unsafe and about to be demolished. There are no other suitable buildings to store this material. The requirements of the hospital take precedence over any commercial enterprises to be run by private parties. RDC, Southern SB, chairman, Swasthya Vikasa Committee had visited twice in the month of May 2024 and urged upon to these as storage for saline and other drugs for which there is a shortage of space till new construction takes place, finalization of master plan. Therefore, the office given
So
the
you
offer.
said you have not received this letter.
well, now, if
Now
they
you
are
receive-
granting another place, also may dispose of directing that within a particular time period, let them carry out all the
That can be done.
formalities and allot the shop.
Miles.
Times to times to please.
No. The petitioner has filed the presented application seeking direction to opposite party number 3 to take necessary steps towards execution of an agreement in furtherance of the allotment later dated 7/2/2024 in respect of shop group number 1 bracketed ground floor in medical campus in the campus of Maharaja Krishna Chandra Gajpati Medical College Hospital, Behrampur. Bracketed SS building in front of SS building. Comma for opening a juice parlor. Full stop. Next, our attention has been drawn by learned AGA representing the state that the said order of allotment of the shop in the ground floor of the multi-utility center has been withdrawn. Full stop. The has been withdrawn by an order passed while by an order passed on the petitioner's representation in pursuant to an order of this court in WPC number 10120 of 2024.
Mail.
Stop. The operative portion of the said order dated 18/6/2024 reads thus. Said order dated 18/6/2024 has been brought on record, has been taken on record. Then operative person of so and so reads thus. Stop. When counsel appearing on behalf of the petitioner has submitted that he was not aware of the said order dated 18/6/2024. So he submits that the petitioner is ready to enter into ready to the decision of the opposite parties in allotment of room number 1 at backside of the milk ATM as referred to in the order dated 18/6/2024. So next in such view of the matter, it is considered fit it is deemed fit and interest of justice to dispose of the writ petition with her liberty to approach the superintendent MK CG Medical College Hospital by next Monday.
1 week time.
By within 1 week with a copy of the present order. Stop. Within 2 weeks.
2 weeks.
Stop. If the petitioner appears before the superintendent MKCG Medical College with a copy of the present order, the superintendent shall proceed to take steps for execution of agreement in terms of his own order dated 18/6/2024.
May I pray, Malad, any time stipulation within 1
weeks?
Malad,
You want more?
Malad, to the superintendent to execute the act.
Soon thereafter.
Soon.
Item 21.
Take steps also soon thereafter.
May I please? This is the second order litigation, my lord. And first order of the summary code is at page 29, annexure 4.
And which item is this?
21.
20.
Yes.
Annexure 4, page 29. This was the order passed in my earlier writ application. I am reading it. The petition is agreed by the decision of the Tahsildar under Annexure 2, selecting opposite partner 4 as the successful bidder. Ignore the said order, an appeal lies before the sub-collector under Rule 46 of the Odisha Minor Miller Constitutional Rules, accordingly leaving it open to the petition to avail such remedy in accordance with the law, it is disposed of. Thereafter, I filed an appeal mail. Appeal was number. And from the last order was passed 19/8/21, fixing 16/9/21 for hearing. Thereafter, no order sheet is
So
made.
your prayer is for disposal of the appeal within a specified.
Yes, yes.
Yes, that can be done.
Within 3 years, no order sheet is maintained.
Yes. So it's for the estate.
A small additional prayer in that there something will not take place. Patti jalti na kon.
Yes.
More, I'll collect it from brief mail from him and.
8 last order.
You don't collect. We will take up the matter after 2 weeks. His grievance is that his appeal is pending.
appeal 21 में सर केस ठीक देइछ ना इतना डिफेक्ट रे केस
I'll take instruction.
No instructions. List this matter on 3 weeks. Within first 5 cases. Stop. Let learn AGA seek instructions as to whether the petitioner's appeal, which was referred in the light of this court's order dated 5/5/2021, passed in WPC number 16186 of 2021, has been disposed of or not.
Item 22.
Disposed of or not by?
Next.
By which authority? Who is the appellate authority?
Sub-collector both.
By the
Opposite
sub-collector.
Change in that thing, would it have affected that? That change of your rules? Sub-collector, now it will go before the DDM?
Take instruction.
Yes. That will be one.
Next week.
3 weeks.
Item 22.
Here your lordship directed the state council to take instruction. This is a case where they made allocation of fund of 60 lakhs to every school for developmental work under the 5T model. Now 10 lakhs is to be retained by the headmaster. The rest 50 lakhs goes to the BDO who does the work without any tender or anything. Though my lord, as per their own circular and everything, they have to put it to tender. Therefore, your lordship was pleased to ask the state council to take instruction. And that is how the matter is today, my lord.
In fact, looking into para 7, the sole case of the petitioner is that instead of following the government resolution of Panchayati Raj Department of 2018 to execute the work through a tender process, it is being conducted departmentally. So, your lordship had directed me to obtain instruction. Although I have obtained instruction, but that is not sufficient because he has only said that it is
file affidavit.
I'll file affidavit. Your lordship may grant me 2 weeks time.
2 weeks time.
And this is being done for all the schools. And your lordship may kindly visualize 50 lakhs each school, no accountability. And the BDO does it under the 5T scheme.
Yes.
Item 23.
My matter is non-issuance of MBA certificate. Non-issuance of MBA certificate. The principal has submitted one compliance affidavit. He written in his documents. He also submitted all the documents to the BPUT. But the BPUT is the authority of this issuing authority of the certificate. So that I pray the opposite party number 2, BPUT, you can issue a direction to release my certificate. I have passed the examination 2008 and I have appeared all the semester, but also 6 years already gone past, but my certificate not released till to date. So that I request you, I am coming to court from January 2 onwards, but also.
Why are you scolding us?
Alert, in Annexure 4, page number 19 and 20, the principal admitted and issued a letter to me regarding submission of all the documents at the BPUT also. You have given to me liberty to for appeal again. Contempt case.
So what were you doing 6 years before you passed your MBA examination?
After MBA, I have appeared the examination the 2016 to 2008. All the semesters are already completed. But also, they are not released my certificate. I am gradually going to college and I request to deputy and also principal. Why not issue my certificate? Already 6 years past, my life is spoiled. What I will do?
They have responded to you asking for certain documents. You have given that copy of letter dated 18/6. Check.
Who is appearing for the other side?
Private party.
Deputy, I am appearing for opposite party number 1. Deputy, the competent authority, they have their separate counsels.
Issue notice. No. Opposite party, BPUT is opposite party number
2.
2, my lord.
Please the institution.
Normally, my lord, senior counsel, Mr. Palit appears.
All right, let notice go.
Notice to accept.
Item 24.
In this case, we'll grant some time to file counter affidavit.
Can I place my miscase, my lord? The entire business has been stopped, my lord.
Since?
My license has been suspended.
Since when?
Since my lord, annexure 9, my lord. Since
Since annexure 9.
24/9.
Huh?
Since 24/9/24, my lord.
24/9/20.
So I apprehend them at take.
I think earlier they have given the license, suddenly they have suspended. But yes, allegation is smuggling.
My lord, smuggling,
allegation,
even if the
I-
FIR was filed,
FIR is there.
charge sheet was filed, my
I
lord.
have also filed the FIR, charge sheet, everything. I have not. So.
And SOCO judge issued, my lord, and after his reply, this was.
Yes,
SOCO judge issued.
After
My lord.
considering his.
After considering SOCO.
No, they have not taken, only they have stated the transporting agency submitted his reply and such regarding statement along with the evidence based on documents not satisfactory and suspended. And I apprehend they may cancel my license.
Time was granted to you on 29/10.
To suspend the license, my lord. My lord.
Time was granted to you to file an affidavit.
My lord. 8/10, my lord, the instruction was directed, he requested him to file an counter.
Now you were asked to file an affidavit.
My lord.
But you did not file.
My lord.
Yes, sheet I have submitted. They have stated that wrongly they have take their other route. Charge sheet I have submitted, my lord. The police submitted the charge sheet on that affair.
Saying that wrongly.
Wrongly, Olga route, I have taken a wrong route, my lord. I have, my destination was Tamil Nadu.
Yes.
But I have taken in a wrong route. It makes it suspicious on me that I could have.
So how can you take a wrong route?
There is no way bill I have submitted. No route chart is there. I have from destination starting point to end point by road. No destination is there.
They suspected that you are
They suspected and I couldn't.
Serious matter.
Smuggling.
Serious,
Somewhere else.
no interim order, Mr.
I only pray let them may have cancelled my license. That's why I pray no coercive action has been taken during.
No coercive, every coercive action can, any coercive action can be taken. If you want that order, we can record that.
Only I pray no coercive action be taken.
No, we can record that any coercive action can be taken.
My lord.
No, any coercive action.
So that's
All right. No interim order. Yes.
Item 25.
25, I seek a short accommodation a lot. I seek a short accommodation a lot. So Mrs. Ratha is on personal difficulty. Yes.
Does this matter next week?
Item 26.
So 26.
Last occasion, Your Lordship has directed the state to file the compliance affidavit. Lordship, on the last occasion, Your Lordship has directed the state to file the compliance affidavit. But my instruction is that encroachment is not yet been cleared, Your Lordship.
Encroachment,
I'll file an
in direction to clear the encroachment.
Yes, Your Lordship.
Yes,
That has not yet been removed, Your
That
Lordship.
sort of order, right?
That is not
Let us
yet been
see.
removed.
Let us see the order. Normally, we don't pass such orders.
Lordship, page 9, Your Lordship. Starts from page 9. May I read the entire order, Your Lordship?
Well, he submitted and it has been removed.
May I submit it? The
You
petitioner.
were supposed to file a compliance affidavit.
Yes, Lord, sir, because I had given the written instruction where we stated with photographs
Remove.
that encroachment is over.
So my instruction is that encroachment is still there, Your Lordship.
All right. That
I'll
is-
file a affidavit
No,
to
no.
that.
Who is encroaching?
A private person is encroaching, Your Lordship.
Whether he was mid party or
He
not?
was a made party to the PIL, Your Lordship.
No, in this case,
Yes.
in
On the
WPC 14686.
Yes, Your Lordship. He
Was
was
he
a party.
noticed?
Yes. Notice was not.
Then behind his back, the order was passed. How can we compel them to
No, no.
evict?
Lordship, a counter affidavit was filed by the state. Well, they have already.
No, this state commissioner.
The order was passed because one enforcement proceeding was already initiated by the Your Lordship.
Contempt proceeding, suppose. Contempt shall be listed.
That private person has not come for dilution of that order, Your Lordship. This order still is there.
No, but how can we dispute their claim that they removed?
I'll file an if Your Lordship permits, I can file an affidavit to that effect.
No contempt.
No, Lordship may kindly appreciate the contempt is there because there is encroachment. The private person still encroached to that field, Your Lordship. And that is a water body, Your Lordship.
Maybe. Maybe. Have you filed your affidavit?
No, but I have given the instruction that on 23rd of September 2024, in presence of the inspector of the Chandaga police station and other staff, the encroachment was removed and he was evicted, and I had given some photographs. So Lordship wanted that it should be brought on Lord's record by way of an affidavit.
So have you filed?
And I have not filed.
File an affidavit.
Yeah, I filed that affidavit because the officer is on transfer, so I could not
All
file
right,
that affidavit.
file an affidavit. 1 week further time is allowed for.
I may be permitted to file an affidavit to bring on the.
Madam,
facts
if
respect.
you have any grievance further, you can file a fresh writ application.
Let them file.
These matters cannot be decided in the present proceeding, in contempt proceeding.
I'm conscious.
See, the persons who were directed to evict, they are saying that they have evicted.
Yes, sir.
You are saying they have not evicted.
Let them file
The
an
persons,
affidavit.
there is no, that is not the question. The question is that according to you, A had encroached upon.
Yes, sir.
Therefore, A should be evicted. A is not a party. So unless A is evicted, according to you, encroachment cannot be said to have been removed. That is very difficult to accept in a contempt proceeding. Every proceeding has its limitation.
Let them file compliance affidavit.
And that too, when the order was passed behind A's back, he doesn't know what order was passed by this court.
I'll verify from the record whether notice has been issued or not.
We have the
I'll
records.
verify, Your Lordship.
We have the records with us. It was the third order which was passed. No, notice was not issued to the private opposing parties.
Your Lordship, grant me some time. I'll verify to that.
Tell again. Only for the time as well for the contemporaries to file compliance. This matter on next Tuesday.
For admission item 34.
Item number 34, we have no
34.
instructions. No instruction. No instruction.
No instructions.
What is your name? Name, please?
Aruma Raut.
Aruma Raut. On behalf of?
Prafulla Kumar, Senior Advocate.
Okay.
Lord, Mr. B. Bhuya name may be reflected for on behalf for opposite party number 6, my lord.
Whose name?
Vivekananda Bhuya, sir.
Where is he?
My lord, he's on his leg, my lord.
He is
I'm
appearing.
appealing for OP number 6.
He is appearing or disappearing?
Appearing, my lord.
Where?
My lord, I filed Wakalatama. Already I filed, but he's on his legs, my lord.
We'll see. Next.
35.
You are appearing from whom?
For OP number 6. Along,
So what is your name?
Vijay Jena.
All right. Okay, 6.
Item 35.
In this case,
Just one moment.
वो जो है ना वो whenever I direct for listing of non matter, that shall be listed only. बहुत आराम करें तो देर नहीं बचेगा.
If not already removed, है ना?
Item 35.
In item 35, my lord, I have taken thrice.
162.
This one. Yes, ma'am.
Yes, which order?
In item 35, my lord, I have taken thrice for substitution, my lord. Only last chance may be given because I have issued letters. They have sent the only death certificates and legal certificates to me.
Must have abated, Mr.
Yes, ma'am. That
They have sent, so on basis of that you have to prepare the petition.
I cannot show the affidavit, my lord.
Yes. So that you cannot ask the officer to come.
Yes, I am.
What is this matter that?
That
so
similar
difficult to
matters are
file?
pending. That is regarding that job contract period, madam. Only like if your lordship.
When your officer is not responding to your letters to come and swear an affidavit. And anyway, why does he have to come? They can swear the affidavit and send the petition to you also.
Yes, ma'am. They have, as if they are thinking that I have to file an affidavit, they have sent all the documents.
Oh, for you to prepare the
I have
petition.
unless
Send them the petition.
my lordship may give me
Is
one
this matter
week.
on 2 weeks? Yes.
Item 37.
This matters, my lord, relates to levy of GST on royalty bills. And if your lordship would appreciate, my lord, after the 9-judge bench, a similar matter from the Rajasthan High Court, my lord, the Udaipur Chamber of Commerce, that's pending. If your lordship would kindly, and the August order of the Honorable Supreme Court, there the lordships have said that an appropriate bench has to be constituted which would decide or keeping the 9-judge bench in view. Udaipur Chamber of Commerce was a decision, my lord, directly on the fact that whether GST is leviable on royalty bills. So since this matter is pending, may I just humbly pray if the lordship would
Where is the matter pending?
before the Honorable Supreme Court notes. This was the 20th, the August order, my lords. This order, my lord, was
So what is left to be decided now?
sorry, my lords. Your lordship may kindly turn to the audit portion, my lords. There, their lordships have said a special bench has to be constituted to hear this matter, my lords. The Registrar Judicial 1 shall take suitable instructions on the administrative side for the constitution of an appropriate bench for hearing the present batch of matters, bearing in mind the disposal of the main proceeding by the 9-judge bench. And this,
That is different.
no, this, my lord, your lordship would appreciate. Still, subject to whatever your lordship see, the
Reference was made to the 9 judges. The reference has been answered. Now individual cases have to be decided by the Supreme Court, which are pending in view of the decision of the 9 judges bench. So equally, those matters which are pending here are to be decided in terms of the 9 judges bench decision. That's all.
Unfortunately, my lord, this issue, my lord, whether GST is leviable and whether this retrospective enhancement of GST, because in these cases, we were paying GST at the rate of 5%. My lords. Then the change in law of law, so where the rate of tax is concerned, that was made on 1st of January 2018 with retrospective effect from 1/7/2017. my lords. That is also the second challenge before your lordships. So there's a dual challenge, my lords. Your lordships are very correct that so far as the first challenge is concerned, we do not have much of a case after the 9-judge bench. But so far as the second matter relating to the retrospectivity of the levy
We will
of
see whether
for that, my lords.
yes, we will see, we will decide.
I just humbly pray the lordship may call it some other time because there are other people not who are.
All right.
Yes.
Is there any interim order?
Yes,
There is an
yes, there is an
Interim order, then since there is an interim order, anyone should
call it after 2 weeks.
begin. No. Weeks is much. We have been waiting for the Supreme Court's decision for last how many? So many months.
Any
And
day,
now since the
any day
decision has
convenient,
come.
but after Diwali, any day convenient. After the
All
Diwali
right.
holidays.
After the
Lordships are reopening.
yes, what is to be decided now?
But already the core issue has already decided. Whether it is royalties tax or not, that has been decided. So my thing is referring on the Udaipur, so Udaipur case which has been referred to the other bench of the Supreme Court, that is the issue of service under the service tax law.
That's a service tax, but whether
under the service tax law. The issue under the service tax law. So now we are under GST, Milord. So therefore, once the GST and once the royalty has been already decided, then Milord, there is no issue so far as the Udaipur case is concerned. So far, I understand Milord concerned. So your lordship picks it on.
Come ready.
Yes, no.
This matter list these matters one hai kitna hai? Only one.
No.
There's a batch. There's a batch.
List these matters on. कोई एक Wednesday हो 2 बजे 2 PM after Diwali. 19/11/2024. To be taken up at 2 PM.
Lordship of keeping
It is made clear that
19th.
19. Made clear that no adjournment shall be granted since the matter has remained pending, waiting Supreme Court's decision. Awaiting a Supreme Court's decision.
Some others,
Your Lordship, some other cases are there. I have given that list in the past, that list is there.
Let this be decided, then other cases are.
Your Lordship. Your Lordship, please.
Just give us the points.
Maybe
Your Lordship.
maybe the councils are different. My learned friend would cooperate and give another list to my honorable court master.
Already
Give the
given,
list.
that has been, that is
Give the
there.
list, we will see. All those cases will.
No, before I have given.
There may be
that
different
list
lawyers who are
in the
appearing for the
past
other
that has
batch
been
cases.
Give the
that
list.
Your Lordship, I'll give.
Give the list, we will see what.
Your Lordship, that list has been attached in the cause list itself. A list of royalty cases as given by Law and ASC kept below.
All right. All right, we will see.
Your Lordship.
Decide the matters.
And please let us know what are the points. 1, 2, and 3. The main point has been decided. What is left, we will see.
Only surviving point would be the rate of tax and the retrospectivity of the application of the tax. Plus with the HSN code, whether at all this particular tax is leviable. That will be broadly two aspects which your lordship have to see. It may not take much of a time. Much obliged. So interim orders to continue. 19.
Grateful.
19th at 2 p.m.
Nice.
Obliged.
Item 38.
This appeal, the order passed by the Honorable Single Judge, subject matter of challenge. The issue involved whether the black mark awarded in addition to the punishment, like stoppage of increment for a 1 year, would fade away on completion of that 1 year period. That was the subject matter issue. Now the petitioner, during his service tenure, he earned 10 black marks for multiple proceedings. Now, in case of one proceeding, he was awarded with 3 black marks with stoppage of increment for a period of 1 year. Now, by earning the 10 black mark, he was removed from service by operation of the rules as per the Odisha Police Manual by. He approached this honorable court challenging that order on the ground that only punishment of black mark would not remain permanently in his service career because the black mark was awarded along with stoppage of 1 increment for a period of 1 year. Now, once that period of 1 year is achieved and the increment is restored, the black mark will also not remain permanent. That is, and the Honorable Single Judge, referring to a full bench decision of the tribunal, which was later confirmed by this court in writ petition, allowed the writ petition saying that once that particular 3 black mark, which was awarded in addition with is quashed and no more remains to be valid in law, then automatically the petitioner does not come within that purview of 9 black mark. So the order of his order of removal has been quashed. Now, if your lordship will look into the statutory provisions.
No, but what is the decision of this court, which has
Yes,
the
that I last occasion I had supplied. My learned friend was not there. The order of the tribunal, your lordship may kindly, if my lords have given the order of the tribunal. So also the order passed by the division bench.
Where is it?
Physically is there, but it was scanned. That's not
Dharmananda Harijan.
It's Sankarsan Dalai case by the tribunal, which was later upheld by this honorable court in WPC 13624 of 2014. Lots of
It's not there. Where is that?
Email lookers. I have no extra copies of that. Many. See that? That is the order passed by the full bench of the tribunal, where your lordship may kindly see. Page 12. Para 12, the reasoning starts. Would frustrate the note appended to so and so, the imposition of double penalty should be avoided. Clause B of 834 provide withholding of increment shall be restored after the period specified. Then, para 14 is the last conclusion, that we answer that the black mark value contained in 835 does not have the effect of expiry of the period for which the reduction, forfeiture, or withholding has been imposed. In such a case, black mark shall not permanently under 837(1). Further, the black mark shall remain permanently under 837 if it is awarded separately as a punishment under 824. That order was challenged by the state in a writ application, that is WPC number 13624 of 2014. That order also I have supplied your lordship.
Yes. Yes.
Let me kindly have a glance to the provision, that is 837 of the Odisha Police Manual.
Yes.
General rules as to the black marks. The black marks shall remain permanently on record and be taken into consideration in dividing the nature and extent of the subsequent punishment. So now, what the tribunal held, that the black mark, once it is awarded along with other punishment in terms of the provisions 835, then it cannot remain permanently. So if the black mark is awarded in terms of 824 as a punishment only, as the only punishment, then it will remain, then it will have the force of 837. Lordship may kindly have a glance to the police manual. The description of the departmental punishments, that is at 824. 824 of the manual. Rule 824.
Yes, the view appears to be incorrect.
My lord, in 7 proceedings in my career, 10 black marks have been awarded. And because of 10 black marks, Rule 836 have been attracted and I have been removed from service. But my view is that the black marks have been wrongly calculated. If black marks will be awarded independently as a punishment, it will have cumulative effect. It will remain permanently in the record. Then 837 will be attracted. But when black marks is awarded as an equivalent punishment.
That is what has been laid down by full bench of tribunal. That view is incorrect. And we may have to refer this matter to a larger bench. Interpreting the provisions Rule 824 835 and 837 of the police manual of full bench of the Odisha Administrative Tribunal, Cuttack bench, has laid down in OA number 2723 had laid down in OA number 2723 bracketed C of 2008. In its judgment dated 18/5/2012 as under paragraph 14. The said decision of the tribunal was put to challenge before this court, giving rise to WPC number 13624 of 2014. The division bench of this court, while dismissing the writ petition by an order dated 1/3/2017, has observed as under.
May I?
Just a minute. This order. Rule 824 of the Odisha Police Manual black mark or marks is one of the punishments prescribed under Rule 824 of the Odisha Police Manual. Rule 834A of the Police Manual. Rule 834 of the Police Manual reads as under. Full stop. Rule 835 and 836. Rules 835 and 836 of the Odisha Police Manual lay down the effect of black marks. Full stop. Rule 837 bracketed 1 in no uncertain terms states that the black marks shall remain permanently on record and be taken into consideration in deciding the nature and extent of subsequent punishments. Full stop. Rule 2 of Rule Sub-Rule 2 of Rule 837 requires the punishing authority to mention in the order, to specify in the order awarding black mark, comma, the number of marks outstanding against the delinquent. So stop. Rule 837 reads thus. Outstanding delinquent. So stop. It further provides that imposition of 2 or more black marks may result in reduction in rank or compulsory retirement or removal or dismissal. Where is that dismissal? 10 black marks?
10 black, that is 836. 836.
Rule 837 reads as under. Full stop. On careful scrutiny of the provision under Rule 824, 834, comma 835, comma 836 and 837 of the Police Manual rules of the Police Manual. We are of the opinion that the view taken by the full bench in its judgment dated What is the date of the judgment dated 18/5/2012 in OA number 2723 bracketed C of 2008 is not a correct view. Full stop. We respectfully disagree with the view taken by the division bench of this court in the order dated 1/3/2017 in WPC number 13624 of 2014, confirming the aforesaid opinion of the Orissa Administrative Tribunal. So stop. Accordingly, we are of the view that the matter deserves to be placed before full bench to decide following legal question for an authoritative pronouncement, Roman 1, Roman 1, whether the opinion recorded by the tribunal in its judgment dated 18/5/2012 in OA number 273 bracketed C of 2008 to the effect that the value contained in Rule 835 does not have effect upon expiry of period for which a reduction, forfeiture or withholding is imposed, and in such cases the black marks shall not remain permanently under Rule 837 bracketed 1 in view of clear stipulation in Rule 830 bracketed 1 that the black marks shall remain permanently on record and be taken into consideration in deciding the nature and extent of subsequent punishments. 2. Whether the view taken by the division bench in the order dated 1/3/2017 affirming the opinion of aforesaid opinion of the Odisha Administrative Tribunal is legally correct. Stop. Let the order be placed before the Chief Justice for the matter to be placed before a full bench.
Only I just wanted to point out, my lord, the division bench order was challenged before the Honorable Apex Court, and this same was dismissed on the ground of limitation. That may be indicated.
जहाँ पे लिखे हैं वो ऊपर division bench judgment. This is a division bench judgment of this court was challenged by the Director General of Police Odisha Kata before the Supreme Court, giving rise to SLP bracketed civil diary number 23651 of 2018, which has been dismissed which came to be dismissed by an order dated 13/9/2019 with the following observation. Question of law kept open for recruitment. Highlight. Yes.
Lord, here the order of the Honorable Single Judge rejecting the writ petition where the order of the MSME, Micro, Small, Medium Enterprises Felicitation Council was challenged, my lord. And your lordship on last occasion, notice was issued. And my lord, this order is a vague order and is a nullity because neither the MSME Act nor the arbitration proceedings were followed. And your lordship's
मैंने कहा जी आप
applicable
मैंने कहा ऐसे नहीं हो पाएगा जैसा आप
lordship-
बता रहे हो कि किस्तों पे आप ही की जगह वैसे मैंने कहा इतना एडजस्ट कर लिया आपके लिए इतना कोऑपरेट कर लिया लड़की की शादी है और इतना करें
Yes.
Your lordship's order is
मैंने जो आज कह रहा है आज 30,000 रुपए जमा करेगा तो
684 by
10
2022 Millard. And following that Jharkhand Urja Vikas Nigam Limited case Millard, your lordship's order is there. Millard.
No, but where is the award passed by MSC
Millard,
Council?
the order is under annexure. Annexure Millard 4 Millard page 54 lords you have a glance. Simply 4 lines order Millard and Millard.
WA 330.
Millard.
This is WA 330.
Millard.
Where is the order?
Page 54 lords have a glance. 52 to 54. Millard, here the date-to-date proceedings it has been recorded.
Council.
Millard, page 53
Council.
starts 52 and 53 last paragraph. Millard, both the parties were present before the council on 8/8 sitting. MSME held on 2/8/20 through video conference mode. Millard, then the learned advocate on behalf of Office 1 submitted that he is to be deleted from the case, but the council did not allow his submission. Moreover, he was directed to liaison the matter with the OP number 2 to make early payment of the petitioner. The case was adjourned to so and so. Then order is the petitioner and OP number 1 were present before the council in its 84th sitting held on 30th of December 2020. The OP number 2 was absent. OP number 2 was myself, Millard. The OP number 1 OCIC submitted that he is the only facilitator, not actual user. The OP number 2 was the actual user. The council observed that the OP number 1 and 2 are responsible to clear the dues.
So there was no termination of any conciliation proceeding.
No, Millard, nothing.
There was no conciliation.
No
proceeding
conciliation,
undertaken.
no provisions were followed, Millard. And Millard, moreover, we are not able to pay. This OCIC, he has placed order before the complainant, before the...
No, that is not the, whether conciliation proceeding was undertaken or not. Who is for the council?
My lord, I am appeared for the OP number 2 and today.
OP number
Yes,
2,
number
who is
2?
OP number
OCIC.
2? Huh?
Odisha Small Scale Industry Corporation.
OCIC. Who is liable to pay the dues if any, Millard? OCIC is the actual authority who has placed the order before the number 3, Millard. And he remained silent and the instead of any conciliation, Millard, the MSME council has passed this order.
So whether notice has been issued, how the matter has been dealt with by the learned single judge?
Millard, Lord Single Judge order is Millard on annexure. Millard, Lord see, Millard 11, page 11, and his lordship has said that the matter requires adjudication. So this writ petition is not maintainable.
My lord, the arbitration.
Lord see the order at page 13 and 14.
My lord, I am for respondent number 2 is appeared today. Or I am the arbitration clause 34 is applicable.
Arbitration clause 34 is applicable.
Arbitration Act, section 34. Even the
You are right that arbitration 34 is applicable. 34 is applicable against an award. Award under the.
MSME award.
Yes, award passed by the council. So there is some procedure prescribed for the council before it passes an award under in accordance with the principles of the MSME Act. So whether it requires conciliation proceeding, whether any conciliation proceeding was held or not. If it was not held, then we will have to interfere.
Not at all, my lord.
All right, tomorrow. Notices were issued. Yes, Anand.
Yes.
Item
40, my lords, item 40 is the next item.
After issue of notice, it has come out of.
Yes, ma'am.
One week. 1 week.
Milord, tomorrow.
What is item number?
Milord, interim order to continue. Your lordship's interim order to continue.
My appearance. My appearance.
You are appearing.
Number 2.
My lords, may I mention item, next item is 40, my lords.
Today I will submit my wakalat.
What is your name?
Chandan Paningre.
Chandan?
Paningre.
Mr. Chandan Paningre. Person to appear on behalf of respondent number 2 and 3.
No, only 2.
I'm sorry. Respondent number 2 and shall file wakalatnama in course of the case.
Already filed.
And has already filed wakalatnama today. His name may be indicated in the conversation.
Item 50,
Interim
your
order to
lordship.
continue.
I am for the petitioner. After the notice issued, they have terminated the contract prematurely. But today they have appeared.
Today I am appearing and filing the.
File in the registry. File in the registry. We will see. Let's tomorrow.
Tomorrow, your
My lord, item 40, may I mention, my lord, with the permission of the honorable court?
Will come on the next Monday, Tuesday.
Please, my lords. My lords, can it be, my lord, in the first 20 matters or 30 matters, because it has already been heard by the honorable courts.
There are so many matters, Mr. Rasar.
Please, my lords, if it can be, my lord, accommodated, because it is fresh in the minds of the of my lords as well as.
Yes.
next Tuesday, your lordship. Okay.
Please, my lord.